Hello, everybody. Very good morning and very warm welcome to this free internal audit training session for the ISO 27701 2019 internal audit training program. And the standard is privacy information management system. And the tagline for this training to get internal auditor certified for the standard ISO 27701 2019. And this training is powered by Quality Asia Certification Private Limited. Next slide, please. So about this PPT slide, this slide is showing the structure of the course. So during the training section, firstly, we will be having the introduction of the standard, then followed by the revision and history of the standard. Then we will be learning about the important concept and then followed by clause 1 to 3, that is scope, normative reference, terms, definitions, and abbreviations. Then followed by clause number 4, that is general. Then clause number 5, PIMS, that is Privacy Information Management System, specific related requirements from ISO 27001, that is Information Security Management System. Then followed by clause number 6, PIMS, specific related guidelines from ISO 27002. Then followed by clause 7, that is additional ISO 27002 guidance for PII controller, that is personally identifiable information controllers. Then followed by clause number 8, that is additional ISO 27002 guidance for PII processors. Then impact of the organization and auditors. Basically, the standard having impact on organization and auditors. Then at last, we will be having the internal auditing concepts and guidelines and practices, basically good practices. Next slide, please. So basically, objective of this course, firstly, gain a clear understanding about the clauses and privacy controls as per ISO IEC 27701 2019, that is PIMS. Then to interpret the requirement for PII controllers and processor in the organization context, we will be this is the objective. Then to understand how to assess the effectiveness of a PIMS standard in managing privacy risks within the organization. Then to learn internal auditing principles, techniques, practices as per ISO 19011 2018 guidelines. And at last, the objective to support the organization in strengthening its privacy compliance and continual improvement. Next, please. So I am delighted to introduce our today's trainer for the training session, Mr. Atul Suri sir. He is BE in Electrical and MBA. He is a certified lead auditor for various ISO standards like ISO 9001, ISO 14001, 45001, 50001, 22000, 27000, 13485, and 26000. He is a BEE, Bureau of Energy Efficiency Certified Energy Auditor, CEA. About his professional experience, he has 30 years plus in experience in the industry with a strong foundation in engineering and management. He has 20 plus years as a seasoned management system auditor, as a trainer, and delivering expertise across the multiple sector. He also worked with various top-notch certification bodies as a lead auditor and a reviewer also, like Quality Asia, Intertech, Apave, Moody International, IRQS, etc. Next, please. So about the Quality Asia, the mission of the Quality Asia is to empower organization with the world-class quality standards and sustainable practices. The vision to be the leading provider of quality assurance and certification solution in India. Basically Quality Asia is an NABCB accredited certification body. Quality Asia is accredited by NABCB National Accreditation Board for Certification Body, which means that their certifications are recognized internationally. Quality Asia is providing ethical certifications. We are committed to providing 100% audit and compliance services, ensuring transparency and integrity in every certification we issue. Then comprehensive expertise. We have a specialized in ISO 27001, ISO 9001, ISO 14001, and many more ISO certification, offering a full spectrum of certification services tailored to the your organization needs. So basically, ISO is providing free ISO internal audit training programs like we are conducting today. We empower your team with a free training and helping you to build internal expertise and maintain a compliance with the international standards. Quality Asia has global reach with local touch, serving the clients across the multiple Indian cities and international locations, we combine global expertise with personalized local service. And Quality Asia is committed to excellence. Our mission is to support businesses in achieving and maintaining their certification, unlocking the new opportunities and improving operational efficiencies. Next, please. So about the free live internal audit training program, we monthly conduct training programs. Our focus is to uh, provide training session on a different ISO standard each month, ensuring continual learning and up-to-date knowledge for your team basically. So as of now, we have conducted 9 trainings so far, and today is the 10 training session we are conducting. So also we are providing flexible learning option. Who have missed a session any chance, no problem. Our training programs are available later for viewing through the Quality Asia School on our website, allowing you all to learn at your own pace. Log into our Quality Asia website for more updates. And about our mission, we are dedicated in increasing awareness about the ISO standards and enhancing internal auditor competence. Our goal is to uplift the industry operational standards by empowering professionals with the knowledge and skills they need to drive excellence in their organization. All right. So here, from here onwards, Atul Suri sir will be taking over the training session. So I would like to invite Atul Suri sir to start the training session from here onward.
Okay, so good morning to all of you. So this training program is on ISO IEC 27701, that is Privacy Information Management System. So this program is continuation to other training programs we have already conducted in the past, like we started off with 9001, then 14,001, 45,001, 22,000, 27,001, 26,000, etc. So this training program is in continuation to that. So today we are discussing about ISO IEC 27701 Privacy Information Management System. Next slide. So ISO IEC 27701, this includes requirements for a privacy information management system, and basically it's an extension for privacy with respect to the standard ISO IEC 27001. So one thing to note here is, since this standard was published in the year 2019, and that time ISO IC 27001 was 2013. So whatever references we get here, so these are with respect to the clauses or the controls which are mentioned in ISO 27001 2013. So that means it has not been updated. This particular standard has not been yet updated as per ISO 27001 2022. And again, it is applicable for any organization that is basically a PII controller or processor. And this is also aligned with other international regulations like GDPR and other international ISO standards like ISO IC 29100. In fact, this 29100 is also updated last year. So that has become 29100 2024 version. Then other IC standards, ISO IC standards 29151 and 29134. Next. So this standard includes the requirements and controls which are mentioned in 27001 with additional requirements which are related to privacy part. So basically there are controls for PII controllers as well as PII processors. So again, this standard has got various sections. So we will discuss about these sections once we come to the clauses and requirements. Next, so basic privacy elements. Next, now first of all, we need to understand what is PII. So PII, there is a reference of 29100 2011, because see, this standard was based is 2019 version. So that is why there is a reference of 2011 version. So as I said, 29100 is already updated to 2024. But since this standard talks about 2011 version, so we will also give reference of 2011 version of 29100. So basically it identifies PII principles, controllers and processors. But first of all, we need to understand what is PII. So PII is personal identifiable information. Now, what is the significance of this? Like advancing technological platforms have changed the way the businesses operate nowadays and includes government legislations. And there are different digital tools also. We are using cell phones, internet, e-commerce, social media. So there's an explosion of supply of all kind of data. And big data, you must have heard about it, as it is called. So this data is being collected, analyzed, and processed by businesses and shared with other companies. And this information which is being provided by big data, it has also enabled companies to gain insight into how to better interact with customers. For example, if you see Google, you visit some places, what kind of information, information you are searching on Google basically tracks all that. You visit some places, Google also tracks that. So basically a lot of information is being collected, and this information ultimately it is being used by various organizations, basically to interact with the customers and also to provide their services to the customers. So this big data basically it has also increased the number of data breaches, and cyber attacks are also happening by various entities who realize the value of this information. So as a result of this, lots of concerns have been raised about how these companies handle the sensitive information of their customers, because they get lot of information about their customers. So so that is why regulatory bodies are also making new laws to protect the data of customers, while users are looking for more anonymous ways to stay digital. So this PII, basically personal identifiable information, can also be categorized as a sensitive PII as well as non-sensitive PII. So what are these PII, sensitive PII and non-sensitive PII? Sensitive PII, this personal identifiable information can be sensitive or non-sensitive. So when we talk about sensitive personal information, this includes various legal statistics related to individuals. For example, your full name or your social security number, or in India, we call it Aadhaar number, your driving license, your PAN number, your mailing address, your credit card information, your passport information, your banking information, financial information, your medical records also. And this list is a very big list. It goes on. It's not the complete list. So what happens is companies which share data about their clients normally use anonymization techniques to encrypt and basically uh, make it in a form which is not personally identifiable. And for example, an insurance company which shares its clients' information with a marketing company will mask this sensitive information included in the data and leave only the information related to the marketing company's goals. For example, you receive bank statements from your bank accounts from various banks. So normally your account numbers, last 2 digits or 4 digits are mentioned, and rest it is all cross. Likewise, it is applicable for your credit card information also. So this is related to sensitive PII, and there can be some non-sensitive PII also. Sometimes there is a very thin line between what is a sensitive PII and what is non-sensitive PII. For example, your date of birth. So you may consider it sensitive also, and you may consider it non-sensitive also. But the other information, like for example, the gender, the race, the religion, the place of birth, this can be considered as a non-sensitive PII also. So we need to understand that what is PII. PII can be sensitive also, PII can be non-sensitive also. So when we talk about ISO IC 291002011, so basically there are certain definitions in that standard, and these definitions have been updated in the new version, that is 29100 2024 version also. So I'll just give some example. For example, PII principles, the persons who provide personal data for processing. So they are known as PII principle as per the standard. And who is a PII controller? PII controller determines the purpose and means of PII processing. And who is a processor? PII processor. PII processor carries out processing of PII on behalf of the controller and according to the instructions. So there can be joint PII controller also, PII controller that determines purpose and means of processing jointly with one or more PII controllers. So these are the definitions. So basically, three terms are there: PII principle, the person who provides his personal data for processing; PII controller is the one who determines the purpose and means of how this processing will be done; and PII processor is the person who actually carries out that processing according to the instructions or the guidelines or SOPs formulated by PII controller. So we are talking about PII principle, PII controller, and PII processor. Next. So PII controller or PII processor. So sometimes it is not always easy to decide, and organization can be both PII controller as well as PII processor, but not for the same processing activity. So there can be different processing activities. For one activity, it can be a PII controller. For other activity, it can be a PII processor. But ultimately, both are important. Both have their responsibilities. Next. So again, these are some definitions which are given, PII and PII processing. So PII processing is operation or set of operations which is performed on personally identifiable information which can be automated or not. For example, collection, recording, structuring, storage, alteration, retrieval, consultation, use, dissemination, combination, erasure, and destruction. So the processing are basic, various activities like collection, recording, structuring, storage, alteration, retrieval, consultation, use, dissemination, combination, erasure, and destruction. And what is PII? According to the definition which is given in ISO IC 29100, any information which can be used to identify a PII principal to whom the information relates or might be directly or indirectly linked to a PII. So this definition according to GDPR is any information which is relating to an identified or identifiable natural person. So basically what is GDPR? GDPR is General Data Protection Regulation of European Union. Okay, so when we talk about privacy principles, so this is the overview of principles. So consent and choice, that is the persons should have the choice whether to allow PII processing or not. Then there has to be purpose, legitimacy and specification. So purpose of processing must comply with the law and be communicated to PII principles. So there are regulations and laws. We will talk about those regulations and laws in subsequent slides. Then collection limitation. Data collected must be limited to what is strictly necessary for the purpose. So collection limitation has to be only for the purpose for which it is collected. Data minimization, minimize PII processing and third parties with access to PII. Then use, retention and disclosure limitation, PII used only for specified purpose, retained only as needed for purpose. And accuracy and quality. So this PII must be accurate, complete, up to date, adequate, and relevant for purpose. So overview of PII privacy principles is consent and choice, purpose, legitimacy and specification, collection limitation, data minimization, use, retention and disclosure limitation, and accuracy and quality. So next slide. Next, openness. Openness, transparency, and notice. So PII principles receive sufficient, clear, and easy to access information. Then individual participation and access. So PII principal should be able to access and review the PII as permitted by the law. So regulations are there. So those regulations have to be followed. Accountability. The organization shall take responsibility for PII processing. Then information security is also required. There should be controls in place to protect the confidentiality, integrity, and availability of data. And privacy compliance, controls, audits, verifications to ensure PII processing meets the requirements. So overview of privacy principles is consent and choice, purpose, legitimacy and specifications, collection limitation, data minimization, use, retention and disclosure limitation, accuracy and quality, openness, transparency and notice, individual participation and access, accountability, information security, and privacy compliance. Next, so relationship with GDPR. So first of all, we need to understand what is GDPR, what are the requirements. So if you refer to international standard ISO IEC 27701, so this is an international standard applicable regardless of the jurisdiction. And there are more general requirements which can be considered and which must be considered in the context of the localization and its application if voluntary. So ISO, like any other ISO standard, this ISO IC 27701, it is also a voluntary standard, and it gives you a justification. It basically gives the general requirements, and these general requirements have to be considered in the context of local legislation. So for example, if we are in India, So we have to refer to Digital Personal Data Protection Act 2023 and the rules being made. Those rules are still under the draft stage. So 2025. And if you are in European Union, then you have to consider basically GDPR, that is General Data Protection Regulation. So these you have to consider. So GDPR is applicable for the organizations which are located in European Union and also for organizations from outside the European Union which process personal data of European Union citizens. For example, some organization is there in India which is basically doing the processing of personal data of the European Union citizens. So GDPR is applicable for them also, and its application is mandatory because it is by law. So PI, personal identifiable information. So there we call it as personal data. So PI principle, we call it as a data subject, and PI controller processor, which is mentioned in 27701, there we call it data controller or processor. Next. So there are next major data protection laws related to PIA. So different countries have got different regulations. So first we talk about GDPR, that is General Data Protection Regulation in European Union. So this applies to organizations which are processing data of European Unions, and these organizations can be even outside India. For example, some organization in India which is processing data of European Union residents. So again, any standard is based on certain principles. So the key principles of GDPR are lawfulness, fairness, transparency, then purpose, limitation, and data minimization, accuracy, storage limitation, integrity, and confidentiality. Then notable requirements which are mentioned are consent management is there, then data subject rights are there. These rights are related to access, rectification, erasure, portability. Then in certain cases, DPO appointment is also required, and breach notification has to be done within 72 hours. And this fine in case of breach can be, or in case of non-compliance, can go up to 20 million euros or 4% of the global turnover of the organization. So this can be a huge penalty on the organization. Next. So in India also DPDP Act is there, 2023, and rules are also being made with respect to that particular act. So these rules right now they are in draft stage, and they were earlier submitted for public discussion also, open forum. Like if you have certain suggestions, you can put in there. But we are just waiting for the publication of the rules. So basically, in India, we are talking about DPDP Act 2023 and related rules 2025. So as of now, these rules are not yet published, but Act is there since 2023. So this DPDP Act 2023 in India, this applies to personal data processing in India and offshore if it is related to Indian users. So here also key provisions are there with respect to clear consent requirements, data fiduciary, and data principal roles. So just to explain you a term. So what is fiduciary? Meaning of fiduciary? Fiduciary is relating to the responsibility to take care of someone else's money in a suitable way. For example, these mutual funds. So mutual funds, basically they are collecting money from you and they are managing your property, or they are managing your money, investing in different ways. So they have got all the financial information. So there are key provisions related to data fiduciary also, data fiduciary and data principal roles. So the literal meaning of fiduciary is this relates to the responsibilities of a person or an organization which manages property or which manages money belonging to other person or organization. So these are the requirements which are there in DPDP Act 2023. We will further discuss those requirements in detail in subsequent slides. And here also huge penalty is there. Penalties up to 250 crores for non-compliance. Next. Likewise, there are regulation in other countries also, like for example, CCPA, CPRA, California, USA. So this applies to businesses with consumers in California meeting revenue or data threshold. And again, the key features include right to know, delete, opt out of sale. And this also introduced sensitive personal information category, data minimization and purpose limitations, and enforcement by California Privacy Protection Agency. Likewise, other emerging and notable frameworks are also there, like LGPD Brazil, which is similar to GDPR and includes data protection officer, consent, data subject rights. So basically, whichever country you are existing, your organization exists, or whichever country's uh, citizens' personal data you are handling, so you have to comply with the rules of that. PIPEDA in Canada, which is privacy law for commercial organizations, and PDPA Singapore, Thailand, Malaysia, which is sector neutral, consent-based framework with enforcement. So now we discuss little bit about our DPDP Act 2023, which was enacted on 11th August 2023 in India, and the objective is to protect personal data of individuals and regulate data processing by data fiduciaries. Data fiduciaries, as I explained, basically these are the organizations which are responsible for managing the property and money belonging to other person and organization. So basically, one of the key objective of this DPDP Act is to regulate data processing by data fiduciaries. So applicability, it applies to digital personal data in India, and it also applies to processing outside India if it relates to goods and services to individuals in India. So likewise for other GDPR also, it is applicable for any processing which is done outside India also if it relates to the goods and services of individuals in India. So this Digital Personal Data Protection Act 2023 marks India's formal entry into global landscape of modern data governance. So unlike previous regulations, it shifts from the focus from mere compliance to accountability. So that is why a huge amount of penalty is there, which is up to rupees 2000, which is up to rupees 250 crores. So placing clear obligations on businesses while empowering individuals with enforceable rights over their digital footprint. So it is very important for the organizations to understand and adhere to this DPDP Act so that they handle personal data within India or process the data of Indian citizens regardless of the geographical location in a proper accountable manner. Next, so first of all, why this Data Protection Act is required in India? So with the rapid growth of digital technologies and online services, the collection and processing of personal data has become increasing prevalent. So prior to this act, India lacked a comprehensive privacy policy, and there was some Supreme Court judgment. While the Supreme Court of India recognized the right to privacy as a constitutionally protected right in 2017, the existing information technology, that is reasonable security practices and procedures and sensitive personal data of information rules 2011, they had certain limitations. So this act was made. This act aims to fulfill, this act basically aims to fill this crucial gap by providing a comprehensive legal framework for data protection in India. And also, prior to this, there was a lack of clarity regarding individuals' legal rights regarding their personal data, and also lack of accountability for organizations which were processing this data. So this DPDP Act establishes the Data Protection Board of India. Basically, it has been enacted or it has been established based on this act only, with the objective of enforcing the law and holding the organizations accountable, thereby empowering individuals with greater control over their personal data. So why this Data Protection Act has been required or enacted in India? Because earlier there were no such regulations, there were no such rules. So though Supreme Court of India identified the right to privacy as a constitutionally protected right in 2017, but the existing regulations, rules, basically they had limitations. So that is why this DPDP Act was made, and basically with the objective of providing a comprehensive legal frameworks for data protection in India. So this basically makes the organizations accountable and also empowers the individuals with greater control over their personal data. Next, status, applicability and scope of this DPDP Act. So this DPDP Act applies to the processing of digital personal data within India, where this data is collected online or offline and subsequently digitized. And it also has extraterritorial application extending to the processing of digital personal data outside of India if such processing is relating to offering goods or services to individuals within India. So that means organizations based outside India, but they are basically providing their services to Indian clients, Indian markets, they also have to comply with DPDP Act. For example, if Indian companies, they are basically processing the European Union citizens data, so they have to comply with GDPR. So likewise, any multinational company, any organization which is based out of India, but basically it is providing services to Indian market, Indian clients. So they also have to comply with DPDP Act, though they may be located outside India. So there are certain exclusions from this DPDP Act, which is personal or domestic use, that is data processed by individuals for personal or household purposes, for example, phone contacts, home videos, and non-automated oblique manual data, offline records which are not digitized or processed by automated means, then publicly available personal data, data made public by the data principal or under a legal obligation, offline personal data, that is physical records not intended to be digitized, for example, handwritten forms stored in files, and law enforcement and national security, because they are basically in a crucial, their nature of job is quite crucial and sensitive information. So they are exempt for data processed under sovereign or legal obligations, and other journalistic, literacy, or artistic purposes. So content created for freedom of expression in media and art. So certain kind of exclusions are there from this DPTP Act, which are personal or domestic use, non-automated manual data, publicly available personal data, offline personal data, law enforcement, national security, and journalistic, literacy, literary, or artistic purposes. Next, we need to understand certain principles, certain definitions. So these definitions have been given in ISO 29100 also. And what are these definitions? Some key principles we need to understand. So the meaning of lawfulness. This principle dictates that personal data must be processed in a manner that is lawful, fair, and transparent to the individuals concerned. This implies that processing must have a legal basis, be conducted in good faith, and provide individuals with clear information about how their data is being handled. So lawfulness means basically you have to comply with the applicable laws. So personal data must be processed in a manner which is lawful, fair, and transparent to the individuals concerned. And the processing must have a legal basis, be conducted in good faith, and provide individuals with clear information about how their data is being handled. The next key principle is purpose limitation. So this principle mandates that personal data should be collected for specified, explicit, and legitimate purpose only, and not further processed in a way incompatible with those original purpose. So the data processing has to be with respect to the purpose for which it was collected. This means that organizations must clearly define why they are collecting personal data and can only use it for those stated reasons unless a new purpose is compatible with the original purpose. Then the third key principle is data minimization. So this principle emphasizes that personal data must be adequate, relevant, and limited to what is necessary for the purposes for which it is processed. So organizations should only collect and retain that personal data which is strictly required to fulfill the specific purposes. So lawfulness, that means you have to comply with the law. Personal data must be processed in a manner which is complying with the laws. Then purpose limitation, so it should be collected only for the purpose for which it is required. And minimal data should be collected. That is, personal data must be adequate, relevant, and limited to what is necessary for the purpose for which it is processed. Then accuracy. This principle requires that personal data is accurate and kept up to date wherever necessary, and data fiduciaries have an obligation to make reasonable efforts to ensure the accuracy and completeness of personal data. So whatever data is being collected, that must be accurate and complete. So that is why in banking sector, these banks normally ask for periodic KYC. So that is also part of that requirement to ensure that the data is accurate and up to date. Storage limitation. This principle stipulates that personal data should be retained only as long as necessary to fulfill the purpose for which it was processed. So data fiduciaries must erase personal data when the data principal withdraws consent or when it is reasonable to assume the specified purpose is no longer being served, unless retention is necessary for compliance with any law. For government entities, storage limitation may not always apply. So storage limitation means, so this personal data should be retained only for as long as it is necessary to fulfill the purpose for which it was processed, and thereafter it should be destroyed. Then integrity and confidentiality. So this principle necessitates that personal data is processed in a manner which ensures appropriate security, protecting against unauthorized or unlawful processing, accidental loss, destruction, or damage through suitable technical and organizational measures. So data fiduciaries, they are responsible for implementing reasonable security safeguards to prevent personal data breaches. So here we are talking about three principles, that is accuracy, storage limitation, integrity, and confidentiality. So key definitions of DPDP Act. So we talked about key principles and definition, that is lawfulness, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality. So if you refer to DPDP Act, this act also defines gives some definitions. So some key definitions we will discuss. So what is personal data? Any data about an individual who is identifiable directly or indirectly. For example, the name, phone number, address, location, ID, employee code. So that is comes under the category of personal data. And what is digital personal data? So personal data in digital form, whether originally collected digitally or digitized later on. So that is known as digital personal data. So personal data is any data about an individual who is identifiable directly or indirectly through that data. For example, the name, phone number, address, location, ID, or employee code. And when you digitize that data, whether collected originally initially in the digital form or it was digitized later on, it is known as digital personal data. And data principal, the individual to whom that personal data relates, including the parents, guardians in case of children or differently abled person. So data principal is the individual to whom that personal data relates. Processing, when you are working on that data, that is known as processing. Any operation on personal data, that is collection, recording, storage, sharing, erasure, which is performed either through automated or partly automated means, is known as processing. And what is data fiduciary? Any entity which determines the purpose and means of processing and must issue notices, obtain consent, ensure accuracy, oblique security, and report breaches. So data fiduciary is the organization or the individual who is responsible for managing your property or money. So they have a responsibility to issue notices, to obtain the consent from you, to ensure accuracy, security, and report breaches. And data processor, an entity that processes personal data on behalf of that data fiduciary under its instructions, because many times these activities are outsourced also. So data processor is any entity which is processing that personal data on behalf of data fiduciary under its instructions. And what is SDF, significant data fiduciary, designated by the central government based on sensitivity oblique volume of data. So they must appoint data protection officer in India. There has to be independent data auditor, and there has to be periodically conducting DPIA. What is DPI? Data protection impact assessment. So we'll discuss about data protection impact assessment. Just like your risk assessment, here you have to do a data protection impact assessment. So there are guidelines as per GDPR also, and this is a requirement as per DPDP Act also. So this DPIA has to be conducted periodically. How it is conducted, what is the methodology, we will discuss about it in subsequent slides. And then consent manager, a registered entity that helps data principals give, manage, and withdraw consent across platforms. So that is known as a consent manager. And any breach of data, personal data breach, any unauthorized access, processing, loss or disclosure of personal data which affects its confidentiality, integrity, or availability is known as personal data breach. So this data breach has to be reported to the DPB and affected individuals. So the terms which we are discussing, which are mentioned in DPDP Act, are the personal data, the digital personal data, the data principal, processing, data fiduciary, data processor, significant data fiduciary, consent manager, and personal data breach. Next. So obligations of data fiduciaries under the DPDP Act. So there are certain obligations, certain expectations, certain responsibilities of these data fiduciaries, which are mentioned in DPDP Act. So that is lawful processing of the personal data. So what they need to do is they must process data only for the lawful purposes, and it has to be consent based or for legitimate use, such as voluntary data sharing by the individual or public interest, medical emergencies, employment, licenses, etc. Then they are also responsible for providing notice, that is clear, concise, and accessible notice before collection, which must include what data is collected, what is the purpose of collection of this data, what are the data principal rights, and what language. So because in India we have multiple language, so language can be English plus any of the 22 scheduled languages as per the user choice. And obtaining valid consent, so must be explicit, informed, and verifiable. And for children that is less than 18 years, their parental or legal guardian consent is required. And there can be deemed consent in certain limited scenarios, for example, legal obligation, vital interest, etc. So what are the obligations of data fiduciaries under the DPDP Act? That is lawful processing of personal data. They have to provide notice, clear, consent, and accessible notice before collection, and they need to obtain valid consent, and which must be explicit, informed, and verifiable. And in case of children, they need to take consent from the parents or legal guardian, and in certain limited scenarios deemed consent also is applicable. Next, continuing further, so right to withdraw consent also. So data principals can withdraw consent anytime, and fiduciaries must provide simple opt-out mechanisms. Then cessation of processing. Processing must stop post-consent withdrawal unless which is required by law or it is covered under a legal exemption. And security safeguards also, they have to implement reasonable security measures and prevent unauthorized access and disclosure destruction or breach, which also includes in audits, encryption, and breach preparedness. And wherever data breach is there, so data breach notification, that is immediate at an intimation they have to give to data protection board, which is set up as a part of this DPDP Act, and also to the affected individuals. So responsibilities of data fiduciaries under DPDP Act also include right to withdraw consent, cessation of processing, security safeguards, and data breach notification. Further next, and their other responsibilities include erasure of personal data. Data must be deleted after the purpose is fulfilled or on the consent withdrawal. Exceptions, exemptions apply in case of legal legal retention by government. There has to be a grievance redressal contact information and publish contact details for data principals to raise the concerns. There has to be a grievance redressal mechanism. So they have to set up responsive grievance systems for which expected turnaround time is 7 days or as per future rules. And children's and disability data handling. So no behavioral tracking or targeted ads should be there, and consent through lawful guardian is mandatory. Next, so additional obligations for significant data fiduciaries. So one are data fiduciaries and other are significant data fiduciaries. So in case of data fiduciaries, we discussed the obligations related to lawful processing of personal data, providing notice, obtaining valid consent, right to withdraw consent, cessation of processing, security safeguards, data breach notification, erasure of personal data, exemptions, grievance redressal mechanism, and children and disability data handling. But when you are a significant data fiduciary, there are certain additional obligations based on SDF status, which is assigned based on volume or sensitivity of data and risk to data principal rights and the impact on national interest or sovereignty. And there are additional obligations for them. So they have to appoint a data protection officer based on who is based in India, then appoint an independent data auditor and periodically conducting DPIAs, data protection impact assessment. So how this data protection impact assessment is done, we will discuss in subsequent slides. So objective is greater accountability for high risk identities. So if you are a SDF, so SDF status is assigned based on volume sensitivity of data, the risk to data principal rights, and the impact on national interest or sovereignty. And additional obligations include appointment of a DPO based in India and appointment of an independent data auditor and periodically conduct data protection impact assessments with the objective of greater accountability for high risk entities. Next, so data principal. Who is data principal? Whose data is being collected? So what are the rights of data principal under the DPDP Act? Right to access information. So you have a right to know what personal data is being collected, what is the purpose of it, and with whom this data collected is being shared. So you have a right to receive clear and comprehensive notice before data collection, and data fiduciaries must explain to you how this data is being processed. Then you have a right to correction and erasure also. Request correction of inaccurate or incomplete data. Request deletion of data when the purpose is fulfilled or the consent is withdrawn. And include the right to be forgotten, limiting future disclosure or processing. And right to nomination also. That is, appoint another person to exercise rights in case of death or incapacity, and ensure that data rights are protected beyond the individual's direct control. So we have talked about three rights here: right to access information, right to correction and erasure, and right to nomination. Next, there are further rights also. Right to grievance redressal, that is, file complaints within the Data Protection Board of India. And these data fiduciaries must provide grievance contact details and they have to respond within 7 days maximum. Then you have a right to object also, object to data processing under specific circumstances. And data fiduciaries must respect objections unless legitimate overriding ground exists. Because if something is covered under law, then they can exercise their right, that right also. But otherwise, you have a right to object. Then right to be forgotten, so which is covered under erasure rights, and individuals can limit the disclosure of their personal data once it's no longer necessary or the consent is withdrawn. And there is a right to data portability also. So earlier drafts including this right, but this is removed from the final act, and no legal provision allows data principals to transfer their personal data between services. So as of now, this is not there. Initial draft included this right, but it is in the final act, it has been removed. And since no legal provision allows data principals to transfer their personal data between services. So when we talk about the rights of data principal, this act, so basically the rights are rights to access information, right to correction and erasure, right to nomination, right to grievance redressal, right to object, right to be forgotten, and this is all. Right to data portability, it was earlier included in the draft, but in the final act, it has been removed. So let's not talk about it. Next, so data protection impact assessment. It is basically a requirement of the standard, requirement of the act. So what is the role of DPIA, why it is required and how it is done? So understanding the role of DPIA, data protection impact assessment. So what is DPIA and when is the DPI needed? A data protection impact assessment is a process to identify and assess privacy risks to individuals' personal data. So this is a mandatory requirement for significant data fiduciaries under the DPDP Act, and it is also considered a best practice for any high-risk data processing activity. So what is DPIA? DPIA is a data protection impact assessment, which is a process to identify and assess privacy risk to individuals' personal data, and it is mandated for significant data fiduciaries under the DPDP Act. So not only DPDP Act, under GDPR also, this is a mandatory requirement that you have to conduct a data protection impact assessment. And this is considered as a best practice for any high-risk data processing activity. And when it is required, use of new technologies, or when you're doing large-scale processing of sensitive data, or the activities that may result in discrimination or harm, or the processing which poses a high risk to the rights, freedoms of data principles. So what is DPIA? DPIA is Data Protection Impact Assessment, which is a process to identify and assess privacy risk to individuals' personal data, and which is mandatory for significant data fiduciaries as per DPDP Act. And it is also considered a best practice for any high-risk data processing activity. And when it is required, when you are using a new technology, or when you are doing large-scale processing of sensitive data, or any activities which may result in discrimination or harm, or processing which poses high risk to the rights, freedoms of data principles. Next, so what are the various steps to conduct a DPIA? So you describe the processing operation, which is the starting step. Describe the processing operation, that is, detail the nature, scope, purpose, and context of personal data use. Then include what data is collected, how long this data is retained, and who accesses this data. So first thing is describe the processing operation. So assess necessity and proportionality. So is the data relevant, adequate, and not excessive, and aligns with the principle of data minimization. So assess necessity and proportionality. Identify risk to data principles, that is, analyze potential impact on confidentiality, integrity, or availability, and evaluate likelihood and severity of harm, just like your risk assessment methodology, and mitigate or manage the risk, define measures to eliminate or reduce privacy risks, and document risk mitigation, acceptance, or transfer decisions. So what are the steps to conduct a DPIA? So first of all, you need to describe the process operation, detail the nature, scope, purpose, and text of the personal data use. Then mention what data is collected, how long it is retained, and who accesses this data. Then access necessity and proportionality. Is the data relevant, adequate, and not excessive? And the data aligns with the principle of data minimization. And then you need to identify the risk to the data principles, analyze potential impact on confidentiality, integrity, or availability, evaluate likelihood and severity of harm, and mitigate or manage the risk, that is, define measures to eliminate or reduce privacy risk, and document risk mitigation, acceptance, or transfer decisions. So if you refer to the European guidelines on DPIA, so again, they also ask for a DPIA, that is data protection impact assessment. So they have identified various steps. So step one is identify the need for a DPIA, explain broadly what project aims to achieve and what type of processing it involves. So you can also refer to some other links or other documents such as a project proposal. And then you need to summarize why you identified the need for DPIA. So this is the methodology for DPIA as per the European guidelines on DPIA. So step one is identifying the need for DPIA. That is, you need to explain broadly what project aims to achieve and what type of processing it involves. And you can also give reference to or link of some other documents such as the project proposal. And then you need to summarize it, why you need to have this DPIA. So first step is identifying the need for DPIA. Then second step is describing the processing. That is, describe the nature of processing. How will you collect, use, store, and delete the data? What is the source of data? Will you be sharing this data with others also? And maybe it can be in the form of a flow diagram or any other way of describing the data flows. So what type of processing identified as likely high risks are involved? So the step two, as per European guideline on DPIA, is describing the processing. Then you also have to describe the context of processing. So what is the nature of your relationship with the individuals? How much control they will have? Would they expect you to use the data in this way? Do they include children or other vulnerable groups? Are there prior concerns over this type of processing or security flaws? Is it novel in any way? What is the current status of technology in that area? Are there any current issues of public concern that you should factor in? And are you signed up to any approved code of conduct or certification scheme once any have been deployed? So you have to describe the context of processing also. Then you have to describe the purpose of processing. So that is, what do you want to achieve? What is the intended effect on individuals? What are the benefits of the processing that is for you and for more broadly? Then step three is consultation process, which mentions or considers how to consult with the relevant stakeholders. So you have to describe when and how you will seek individuals' views or justify why it is not appropriate to do so. Who else do you need to involve within your organization? Do you need to ask your processors to assist? Do you plan to consult information security experts or any other experts? So that is a consultation process, step three. Step four is assessing the necessity and proportionality. So you have to describe compliance and proportionality measures in particular. What is your lawful basis for processing? Does the processing actually achieve your purpose? Is there any other way to achieve the stated outcome or the same outcome? Then how will you prevent function creep? How will you ensure data quality and data minimization? What information will you give to the individuals? How will you help to support their rights? And what measures do you take to ensure processors comply? And how do you safeguard any international transfers? So that is part of step four, that is assess necessity and proportionality. Then step five is identifying and assessing the risk. So describe the source of risk and nature of potential impact on individuals, which includes associated compliance and corporate risks as necessary. So basically you have to identify the likelihood of harm, maybe in terms of remote, possible or probable, then severity of harm, it can be minimal, significant or severe, and overall risk, which can be low, medium or high. And then finally, you have to identify measures to reduce the risk. So you need to identify additional measures you could take to reduce or eliminate the risk which you have identified as medium or high in step four, because low risk is acceptable, but if the risk is identified as medium or high, so what steps you are going to take to reduce it further? So you identify the risk, then you make the options to reduce or eliminate the risk, and then you study the effect on the risk, that is whether it is eliminated, reduced or accepted, and what is the residual risk. So whether it is low, medium or high, and whether the measures are approved or not. So then and then
May I
finally
disturb you? Sorry to disturb, but what kind of slide is being presented?
no, I'm not referring to any slide. I'm just explaining similar thing, like these steps are there in DPIA, which are part of DPDP Act, but similar kind of DPIA is required as per the European Union Act also, European Union guidelines. So basic methodology remains the same, but steps are a bit different.
Thank you, sir.
So I'm just elaborating further on, like this particular DPI, this particular steps to conduct DPIR are based on DPDP Act. But what I'm trying to explain is that in addition to DPDP Act, there are certain guidelines which are mandated by European guidelines on DPIR also. The basic methodology remains the same, but steps could be a little bit different. But ultimate outcome remains the same. So you can use any methodology. Idea is that you have to do a DPIA, basically impact assessment you have to do. So I'm not referring to any slides here. I'm just explaining this particular slide also, this slide only, but with reference to European guidelines on DPIA. Okay, next. And finally, then you do a sign off. So again, coming back to the slide, managing consent under DPDP Act. So valid consent must be free, specific, informed, unconditional, and unambiguous, and it has to be provided through a clear affirmative action. Pre-consent notice. So this is the methodology for managing consent under the DPDP Act. See, we are based in India, we are following DPDP Act, so we are more concerned about that. But simultaneously, I'm also trying to explain what different countries or different methodologies can be there for DPIA or which are required under the respective legislation. So managing consent is a requirement of DPDP Act. So valid consent must be obtained, which is free, specific, informed, unconditional, and unambiguous, and it has to be provided through a clear affirmative action. Pre-consent notice is required. So organizations must give clear, accessible privacy notices before collecting the data. And these notices must include what data is being collected, what is the purpose of the use, and how to exercise rights and file complaints. And blanket consents are not required. So consent must be purpose specific and no bundled or generalized consent for multiple uses. And consent withdrawal must be easy as giving consent, and organizations must record consent details, allow simple opt-out or track the withdrawals. So as a part of same managing consent, re-evaluation of data practices, review and realign data collection and processing activities with the consent principles. Then timely rights fulfillment, that is ensure clear procedures and timely responses to requests for access, correction and erasure. And access requests, that is verify, identify of data principle and provide summary of data being processed, processing purposes and activities, and who are the recipients of the data. Next, then there can be correction requests also. Allow data principals to request rectification of inaccurate oblique misleading data and completion or updating of data. There can be erasure requests also. So they must delete personal data upon withdrawal of consent and retain it only if it is legally required. And then they must set up dedicated channels, train staff, and identify verification processes and maintain clear records to support compliance and timely resolution of data principal requests. So basically under managing consent under the DPDP Act, the obligations are, first of all, valid consent must be obtained, pre-consent notice is required, blanket consent is not allowed, and consent withdrawal methodology must be there, which must be as easy as giving the consent, and organizations must record consent details, allow simple opt-out and track withdrawals. Then re-evaluation of data practices can be done, review and realign data collection and processing activities with the consent principles, timely rights fulfillment and access requests. And in addition, there can be correction requests, erasure requests, and they have to set up, organizations have to set up dedicated channels, train staff, and identity verification processes. And they also have to maintain records to support compliance and timely resolution of data principal requests. Next, so as part of this DPDP Act implementation in India, Data Protection Board of India set up. So this is an independent body for enforcement. So this can receive complaints, conduct inquiries and investigations, and it can also impose penalties up to rupees 250 crores per instance, and also oversees voluntary undertaking. So this Data Protection Board of India has got a key role to play when we come to the implementation part. So there are huge penalties under the DPDP Act: breach or obligations up to 250 crores, failure to report breach 200 crores, and failure to safeguard children's data 50 crores, and non-compliance with data principal right 10,000 per individual. So there are big penalties under the DPDP Act also. Next. So now we come to the context of our standard ISO IC 27701, because see, any standard you implement, even if you implement 9001, there are product related regulations which you have to follow if your product comes under this category. Then if you implement 14001, you have environmental laws regulations to follow. If you are implementing 45001, then you have got this safety regulations, factory act, etc. to follow. So likewise, when you are implementing ISO IC 27701, then again, DPDP Act or the local legislation or the international regulation that applies to you, that you have to follow. So when you are implementing this standard, so basically it creates a documentary evidence, and important thing is that these standards requirements are mapped to GDPR or DPDP Act or the applicable frameworks. And ultimately, once you are certified to that standard 27701, so this gives assurance and confidence to the regulatory bodies as well as your clients and international international clients, national and international clients. So these are the benefits of implementing the standard 27701. Next. So certain terms which are used in ISO IC 27701: Privacy Information Management System, PIMS. So alternative term can be Personal Information Management System. Then personally identifiable PII can be even known as personal data. Like we saw in GDPR, so it was mentioned as personal data, and PII principle was considered as alternate term was used as data subject. So PII principle is equivalent to data subject. PII, personal information, personally identifiable information, is equivalent to personal data. Privacy Information Management System is equivalent to Personal Information Management System. Privacy by design is equivalent to data protection by design. Privacy by default is equivalent to data protection by default. PII controller is equivalent to controller, and PII processor is equivalent to processor. Next. So again, some definitions which are mentioned in the standard 27701. Personally identifiable information, PII: any information which can be used to establish a link between the information and the natural person to whom such information relates, or can be directly or indirectly linked to a natural person. So as we discussed in the beginning, that this PII also basically information can be it can be sensitive information as well as non-sensitive information. Sensitive PII or non-sensitive PII. Sensitive PII is like your full name, your Aadhaar card or social security number, your driving license, mailing address, credit card information, passport information, financial information, medical records. And there can be some non-sensitive PII also, like your race, gender, date of birth, place of birth, religion, etc. Privacy Information Management System, PIMS. The definition is Information Security Management System, which addresses the protection of privacy as potentially affected by the processing of PII. And who is PII principal? Natural person to whom the personally identifiable information relates. And controller, PII controller, privacy stakeholder or stakeholders which determine the purpose and means for processing personally identifiable information other than natural persons who use data for personal purposes. So these are some of the definitions which are given in the standard. PII processor. privacy stakeholder, which processes personally identifiable information on behalf of or in accordance with the instructions of a PII controller. Privacy risk, effect of uncertainty on the privacy, and then PIA, privacy impact assessment. The overall process of identifying, analyzing, evaluating, consulting, communicating and planning the treatment of potential privacy impacts with regard to the processing of personally identifiable information framed within an organization's broader risk management framework. So PIA, we already discussed the methodology, overall process of identifying, analyzing, evaluating, consulting, communicating, and planning the treatment of potential privacy impacts with regard to the processing of personally identifiable information framed within an organization's broader risk management framework. So this is also like all other management system standards. This is also based on PDCA cycle, that is plan, do, check and act. So this is how the structure of this ISO IC 27701 standard is there. So total 8 clauses are there with further sub clauses. So clause number 1, 2, 3, scope, normative reference, terms and definitions. Clause number 4 is general. So it talks about structure of this document, application of 27001 2013 requirements. So since this was published in 2019, before 27001 2022, so this is based on 2013 requirements of ISO 27001. So application of 27001 2013 requirements, application of 27002 2013 guidelines. So requirements are there, guidelines are there, and 4.4 is customer. Then management processes functions are covered under clause number 5. PIMS specific requirements related to ISO IEC 27001. That is general, context of organization, leadership, planning, support, operation, performance evaluation, and improvement. Then clause 6 is based on PIMS specific guidelines related to ISO IEC 27002. That is the guidelines. So 6.1 to 6.14, general information security policies, organization of information security, human resource security, asset management, access control, cryptography, physical and environmental security, operation security, communication security, systems acquisition, development and maintenance, supplier relationship, information security, incident management, information security aspects of business continuity management and compliance. Then there are further additional ISO IC 2702 guidance for PII controllers, that is general, conditions for collection and processing, obligations to PII principles, privacy by design and privacy by default, PII sharing, transfer and disclosure. And then there are additional guidelines for additional ISO IC 27002 guidance for PII processors. So these are general conditions for collection and processing, obligations to PII principles, privacy by design and privacy by default, and compliance. So this is the overview of ISO IC 27701 standard with clause number 1 to 8. So basically 1, 2, 3 are the initials, that is scope, normative reference, terms and definitions. Then 4, 5, 6, 7, 8 have further sub clauses. So these sub clauses we will discuss next slide. Okay, so there is a small exercise.
Yeah, all right, sir. So, dear participants, we are having a small workshop right now. So Sagar has shared the barcode on the screen. You can just scan the barcode and you will be getting the access to the questionnaires and just submit your responses for the questionnaires. Sagar, please share the link in the chat box. Thank you. Sagar has already shared the link in the chat box. So you can just click on the link and you can submit your responses. So I request all the participants to participate in this workshop very actively and submit their responses so that we can have maximum number of responses for this exercise. So these workshops are provided in this training session to engage, basically to increase your engagement and to make the training session more interactive, right? So I again request kindly submit your responses as much as you can. We are waiting for a few responses to come. Then we will go with the stats for this exercise. And also for your information, after completing the training session, we will be having the question answer session regarding this standard, regarding the training program. So during the training session, if you are having any questions, having doubts regarding the standards, regarding the internal audit training program or anything else, so just make a note of it, and we will be definitely answering your all questions and your queries at the end of this training session.
There is a small request. May I talk?
Yes, please. Yes.
Because when we discuss these things, there are many things which come in our mind, and there are some questions based on that. So if those questions are resolved at that moment of time, that will be giving better, means higher impact, because those unresolved queries piled up and particularly lose the context at the end of the program. So
Yeah.
the impact is more if those queries are resolved at the right time when they arise, because those slides are over there, and particularly the knowledge is built up based on that. So
Yeah,
this is
sir.
a small request from my side. You may take a call on that.
Yeah, understood, sir. And thank you for giving your feedback and your suggestion. Basically, sir, during the training program, the flow is built up for the training, and you know that it is a, sir, 8-year training session, and we are covering the 2 days training content in this training program. We
Yes.
appreciate that we should do that, but due to the time constraint, we are not able to, you can say, solve your query during that instance only. So at the end of the training session, we will be resolving and showing the, you can say, the that PPT or then training slide at that moment only, right? So I hope that you can understood our time constraint for that. All right, Sagar, please let me know once we have received the responses for the workshops. Yeah, so Mr. GVS Sai has done great. Congratulations, Mr. GVS Sai. Yeah, Mr. Satya Surya Pradeep has already submitted. Congratulations, Mr. Suryadeep Pradeep. We are waiting more responses to come. Mr. Devdeep Ghosh has submitted. Congratulations, Mr. Devdeep ji. So we are awaiting a few more responses. It's JRP, AJRP, Mr. Submitted. Congratulations, Mr. AJRP.
I have also submitted, sir.
Yeah, thank you, sir. Thank you for the update and congratulations for your actively participation. Swati Kulkarni ji submitted. Congratulations, Swati ji. Bara Neeraj ji submitted. Congratulations. Dr. Santosh Rane has already submitted. Congratulations, Dr. Santosh ji. Mr. B. Krishna Kumar submitted. Congratulations, Krishna Kumar ji. So we are now started receiving responses. Shortly, we will be checking the stats. Mr. Yatish Kumar submitted. Congratulations, Yatish ji. All right, sir. All right, sir.
So is it necessary to scan the code?
No, sir.
Sorry.
Get it, the link.
Can you repeat again, please?
Is it necessary to scan the code? What is
No, sir.
displayed?
You can just click on the link provided in the chat box.
Yes, we have already done it.
Yes, already. That's great. Mr. Amit Pal submitted. Siva Teja, Mr. submitted. Great, congratulations. Priyansh submitted. Congratulations, Priyansh Sharma. Mr. Ashok Sharma all submitted. Congratulations, Mr. Ashokji. Yeah, Mr. Subham Singh has raised up the hand. Yes, Mr. Subham. Mr. Subham. So now we have the stats on the screen. Sagar, can you share the screen, please. All right. So we have received 23 responses for this workshop. Yeah. The first question, ISO IEC 27701 is an extension of which standard? And the correct answer for this question, ISO IEC 27001. And 100% answers, we received the correct answers. So congratulations all the participants who have submitted correct answer. Next, please. Second, I think we move on to third question. Second question, please. And what is first question? Okay, so we have passed the first question. The first question is, what is the primary objective of ISO IEC 27701? And again, the correct answer is to provide requirement for privacy information management system, that is PIMS. And also for this question, we have received 100% responses are the correct ones. Again, congratulations to all. Sagar, move on to next third question, please. So third question, according to ISO IEC 29100, what qualifies as personally identifiable information, PII? And the correct answer for this question, any information that can be used to identify a natural person. And 91% answers are the correct answers. So again, congratulations to all. Next, please. Yeah, fourth question, which of the following is not a recognized actor in the privacy framework per ISO IEC 27701? And that is PII developers. And that is for this question, we have received 66% are the correct answers. So again, congratulations who have submitted correct answers for this question. Sagar, next, please. Yeah. Fifth question, which legislation in India aligns closely with the objective of ISO IEC 27701? And the correct answer, Digital Personal Data Protection Act, that's it, DPDP Act 2023. And for this question, we have received 95% answers are the correct answer. So I again congratulate all the participants who are actively participated and submitted their responses. Now I am handing over this training session to Atul Suri sir to resume training.
So now we start with the clause number 4. So clause number 4 has 4 subclauses, 4.1, 4.2, 4.3, 4.4. So 4.1 is structure of the document, 4.2 application of ISO IEC 27001 2013 requirements, 4.3 is application of ISO IEC 27002 2013 guidelines, and 4.4 is customer. Next slide, please. So 4.1 is structure of this document. So this standard extends ISO 27001 and ISO 27002 to include, so 27001 is the requirements and 27002 is guidance, to include privacy management, focusing on protection of personally identifiable information. And clause number 5 and clause number 6 provide PIMS specific requirements and guidance, which is aligned with 27001 and 27002 respectively. So 5 is aligned with 27001 and 6 is aligned with 27002 and providing PIMS specific requirements and guidance. And clause number 7 and 8 introduce additional controls for PII controllers and PII processors. So then in the standard, there are annexures also. Annexure A and B list specific control objectives, and annexure C to F provide mapping to various related standards like 29100, GDPR, ISO 27018. And this structure enables seamless integration of privacy into existing ISMS frameworks. For example, there must be several organizations which are already certified to ISO 27001. So by referring to these additional requirements, and they can align their existing ISMS framework with PIMS specific requirements also. So 4.1 structure of this standard 4.1 basically addresses these requirements. Next, then 4.2 application of ISO 27001 2013 requirements. So there is a table given, location of PIMS specific requirements and other information for implementing controls in 27001 2013. So these are the clauses which are mentioned in 27001 2013, clause number 4, 5, 6, 7, 8, 9, 10. That is context of the organization, leadership, planning, support, operation, performance evaluation and improvement. And The respective subclause in this particular document, they have been mentioned, like 4 is synonymous to 5.2, and for 5 it is 5.3, planning it is 5.4, support it is 5.5, operation it is 5.6, performance evaluation is 5.7, and improvement is 5.8. So in context of the organization, there are additional requirements, and in planning there are additional requirements, but in remaining clauses, there are no PMS specific requirements. So the extended interpretation of information security according to 5.1 always applies even when there are no PMS specific requirements. So basically, this is a table which basically aligns with the requirements of ISO 27001-2013 requirements. Next. Then 4.3 is about, there is also a table given in 4.3, application of ISO. Now we are talking about the guidance documents. ISO IEC 27002-2013 guidelines. So these are the clauses which are given in 27002-2013, that clause number 5 to 18, that is information security policies. So corresponding document is 6.2, additional guidance is there. Likewise, additional guidance is there in except 17, clause number 17, there are additional guidance is there with respect to information security policies, organization of information security, human resource security, asset management, access control, cryptography, physical and environmental security, operation security, communication security, system acquisition, development and maintenance, supplier relationships, information security, incident management, information security aspects of business continuity management, and compliance. So except 17, that is information security aspects of business continuity management, there are additional guidance with respect to all other requirements which are explained in 27002-2013, and corresponding clause number of this particular standard, that is 27701, has been given, which are basically addressed in clause number 6, that is 6.2 to 6.15. So the extended interpretation of information security according to 6.1 always applies even when there is no PMS specific guidance. Okay, next. Then the term customer has been used, 4.4, customer. The term customer is contextual and depends on the role of the organization in the PII processing chain. So what kind of customers? An organization with a contract with PII controller. For example, the end customer of the controller can also be joint controller. PII controller with a contact with a PII processor, for example, customer of the processor, and PII processor contracting a PII sub-processor, for example, customer of the sub-processor. So this is what is mentioned in clause number 4. So depending upon the role of the organization, customer can be understood as either an organization who has a contract with the PII controller, for example, the customer of PII controller, and this can be the case of an organization which is a joint controller, and an individual person in a business to consumer relationship with an organization is also referred to as PII principal in this document. And customer can be a PII controller who has a contract with a PII processor, for example, the customer of PII processor, and can be a PII processor who has a contract with a subcontractor for PII processing, for example, the customer of subcontracting processor. Okay, so this is all about clause number 4. Next. So this is an exercise, and after this exercise, we'll have a tea break for 15 minutes. Yes, continue, please.
All right, sir. So, Sagar, please share a barcode. Yes, already shown, and also share the link in the chat box for this workshop. So, dear participants, I request all to actively participate in this workshop as well, as you submitted your responses previously also. So, I am expecting more responses as for this training for this workshop also. And those participants who submitted, kindly provide their names in the chat box. Sagar, once we receive few responses, please let me know. We will go with the stats. All right, Mr. Faizan Malik submitted. Congratulations, Mr. Faizan Malik. Mr. Mandeep Rawal already submitted. Congratulations, Mr. Mandeep. I'm waiting for few responses and their names to receive. Mr. B. Kumar, Krishna Kumar submitted. Congratulations, Mr. Kumar. Mr. Yatish Kumar submitted. Congratulations, Yatish ji. Mr. Rahul Sharma submitted. Congratulations, Mr. Rahul. Sagar, please let me know once we receive the responses, few responses for the workshop. Mr. Teja Praneeth has submitted. Congratulations, Mr. Teja Praneeth. Bara Neeraj Raj submitted. Congratulations, Mr. Bara Neeraj Raj. Mr. Subham Singh submitted. Sorry. Yes, congratulations, Mr. Subham Singh. All right, so we have received 13 responses as of now, and more we will be showing few more. So the first question for the workshop: what does clause 4.2 of ISO IEC 27701-2019 describe? And the correct answer for this question is structure of the document. And we have received 71% answers are the correct answers. So again, congratulations to all. Next, please. Second question, according to clause 4.2, ISO IEC 27701 extends which standard to include privacy protection? And the correct answer is ISO IEC 27001, that is Information Security Management System. And for this question, we have received 88% answers are the correct answers. Next, please. Question number 3. Clause 4.3 of ISO IEC 27701 2019 is focused on. And the right answer, application of ISO IEC 27002 guidelines. And for this question, we have received 88% answers are the correct ones. Congratulations to all who have submitted right answer for this question. Next, please. Fourth question, which clause defines the roles and contractual relationship of customers with PII controllers or processors? And the right answer is the clause number 4.4. And for this question, we have received 76% answer are the correct answers. I am again congratulating all participants. Next, please. Fifth question for the workshop, what is a key takeaway from clause 4.2 and 4.3 in ISO IEC 27701-2019? And the right answer for this question, they offer PIMS specific guidance and refinement of ISMS requirements and controls, and 82% answers are the correct answer for this workshop. So I again congratulate all the participants for submitting their responses and actively participating in this workshop.
Okay, so now we'll start with clause number 5. These are PMS specific requirements related to ISO IC 27001. So we have 5.1 to 5.8. 5.1 is general. 5.2 is context of the organization. 5.3 is leadership. 5.4 is planning. 5.5 is support. 5.6 is operation. 5.7 performance evaluation, and 5.8 improvement. Next. General 5.1, the term information security in ISO IC 27001 2013 must be extended to include privacy protection, specifically the protection of personally identifiable information. So all controls and requirements which are mentioned in ISO 27001 should be applied with a dual focus, that is on information security and privacy of PII subjects. So it says that the term information security is now extended to include privacy protection also, with specifically the protection of personally identifiable information, and whatever controls are there in ISO 27001, they have to be applied with a dual focus, that is on information security as well as privacy of PII subjects. So wherever information security appears in ISO 27001, so you have to read it as information security and privacy. So when you are implementing ISO 27701, so you have to read it in conjunction with 27001, and wherever 27001 requirements are identical, so information security you have to read as information security and privacy, because here we are extending this term to include privacy protection also, which specifically focusing on protection of personally identifiable information, that is PII. Next. So context of organization is requirement of all the management system standards. So it is there here also, context of the organization. The organization must determine its role as a PII controller, joint PII controller, and or PII processor. So context of the organization, basically first organization has to determine its role. So whether it is a PII controller or joint PII controller and or PII processor. So then you have to identify external and internal issues which are relevant to the purpose of the organization and its PIMS, that is Privacy Information Management System. So when you consider external and internal issues, so normally you consider the external issues which are quite important in this case are the regulatory requirements, the applicable acts and rules. And then you also have to consider the internal issues, which are basically normally we use the SWOT analysis of the organization for determining its strengths, weaknesses, opportunities, and threats. So examples of relevant factors are applicable privacy legislations, then relevant regulations and judicial decisions, internal governance, policies and procedures, administrative and contractual requirements, customer related requirements. And if the organization acts as both controller and processor, each role must be evaluated separately with distinct controls. So when you talk about understanding the organization and its context, so the organization has to determine external and internal factors which are relevant to its context and which affects its ability to achieve the intended outcome of its PIMS. And for that, you need to consider applicable privacy legislation like GDPR Act or DPDP Act, the regulations, applicable judicial decisions, applicable organizational context, governance, policies, procedures, applicable administrative contracts, controls or decisions, and applicable contractual requirements also. And when you have, when the organization is acting in both roles, that is, it is acting as a PII controller as well as a PII processor. So separate roles have to be determined, and each of which is the subject of a separate set of controls. Because for each control, for each role, you need to have a separate set of controls. So as a part of your understanding the context of the organization, you also need to identify your interested parties. So like you are identifying in all other management system standards. So organization must identify interested parties which have interest or responsibilities in relation to PII processing. And these include PII principals also, that is data subjects. And examples of these are interested parties are customers, supervisory authorities, other PII controllers, PII processors, and subcontractors. So organization has to include among its interested parties, you have to include those parties which are having an interest or responsibilities associated with processing of PIIs, including the PII principals. And your other interested parties can include customers, supervisory authorities, other PII controllers, PII processors, and subcontractors. And when you also have to consider requirements relevant to the processing of PII by identification of legal and regulatory requirements, the contractual obligations, and organization's own objectives and targets. So you can refer to the privacy principles which are set out in ISO IC 29100, which provide the related guidance concerning the processing of PII. Next. So like all other management system standards, here also you have to determine the scope of the PIMS. So this is an additional requirement because ISO 27001 4.3 was determining the scope of information security management system. So here you have to include the processing of PII, personal identifiable information, also as a part of your scope of information security management system and PI, because now we are talking about PIMS. So basically you have to determine the scope of PIMS, which requires revising the scope of your information security management system because of your extended interpretation of information security, because we are talking about information security and privacy. Next. Then this is generic requirement: establish, implement, maintain, and continually improve your privacy information management system standard. Next. So no specific requirements are there. Leadership, whatever requirements are there in ISO 27001. So same applies here also, because leadership plays an important role in all management systems. So they provide the resources, they ensure that proper job responsibilities are allocated to the concerned personnel. So no additional specific requirements related to privacy addition. Only thing is the top management of the organization must support must provide the desired support for the management system. So your policy on information security and privacy, like information security policy you have got in your organization, if it is certified to ISO 27001, now you have to extend this policy to include the privacy aspect also. So policy must be written, communicated, and available to interested parties as appropriate. So this is one example of a sample policy. Information security and privacy policy statement. SEC prides itself as being a leader in IT service industry. As part of this, we recognize that we have a responsibility to protect all the data we hold or process, whether it belongs to SEC, our employees, partners, customers, or suppliers. So we are talking about the privacy part also. Privacy policy also it is added. By protecting this data, we can ensure that we maintain our reputation as a trusted employer and partner, enabling us to grow as a business and deliver exceptional service to our customers. To demonstrate our commitment to information security, SEC implement industry best practices, security controls, and assure the effectiveness of our controls through certification to ISO 27001. So basically, it has addressed privacy part also, which is important that we have recognized that we have a responsibility to protect all the data we hold or process, whether it belongs to SEC, the name of the company, our employees, partners, customers, or suppliers. And by protecting this data, we can ensure that we maintain our reputation as a trusted employer and partners, enabling us to grow as a business and deliver exceptional service to our customers. So rest of the part is related to ISMS. Okay. Next, so basically it's a modification of existing information security policy to add privacy policy part of the statement also. Next, so organizational role, responsibilities and authorities. This is a requirement in 27001 also. So no specific privacy edition. So the requirements of 27001 apply. So responsible to ensure that management system conforms to the requirements, and there is a mandate for appointment of data protection officer in case GDPR is applicable. That means if you are providing services to some or you are processing data of European Union citizens, in that case GDPR will become applicable, and then you need to appoint a GDPR data that you need to appoint a data protection officer also as a part of requirement of GDPR. So organization roles and responsibilities, no new requirement is there with respect to 27001, but additionally you need to appoint a data protection officer if GDPR requirements are applicable for you. Next, so planning, risk assessment and treatment. Organization shall define and identify a risk assessment process, including risks related to PIA processing. So the methodology which you are using in ISO 27001, assets, threats, and vulnerabilities. So assets, you also identify personal data of employees stored on company servers. Threat is an unauthorized access, and vulnerability is no access restrictions. Next slide. So information security risk assessment. So organization must use information security risk assessment, and you need to address privacy risk assessment also related to PII processing. So information security risk assessment, when you are doing, use information security risk assessment for confidentiality, integrity, and availability. And you need to add privacy risk assessment also for risks related to PII processing, and ensure that both type of risks are consistently managed or interlinked, and assess consequences for both the organization and PII principles if risk materialize. So additional thing is information security risk assessment you are already doing as part of 27001, but you need to add privacy risk assessment also for risks related to PII processing. And you have to ensure that both type of risks are consistently managed and interlinked. That means the same methodology you are using and interlinked. And you have to evaluate the consequences for both the organization and PIE principles if those risks materialize. So two type of methodologies you can use. One is a qualitative risk assessment and another is a quantitative risk assessment, as you are doing for your ISO 27001. So in both cases, you are identifying impact and likelihood. So in qualitative risk assessment, the impact is in terms of insignificant, moderate, or catastrophic, and likelihood in terms of highly unlikely, possible, and probable. So likewise, you are identifying your risk as low risk, medium risk, or high risk. And when you're doing quantitative risk assessment, you are using a scoring methodology. For example, low is 2, medium is 6, high is 10. And here low is 2, medium is 6, impact is high. So according to the score, so maximum can be 10 into 10, 100. So likewise, you are identifying the scores again in low, medium, and high category. Next. So information security risk treatment, like once you do a risk assessment plan, then you need to make a risk treatment plan also. So this clause builds upon 27,001 2013 clause 6.1.3 by introducing privacy specific consideration in the risk treatment process. So risk treatment process as a part of your risk assessment plan, you are doing risk treatment plan also. So here you have to extend this risk treatment plan to your privacy specific considerations also in the risk treatment process. So basically you have to refer to Annexure A 27701, then you have to refer to 27701 Annexure A for PII controllers and 27701 Annexure B for PII processors. The purpose is to ensure that no necessary controls are omitted, especially those protecting PII. So when you are making a risk treatment plan, you need to refer to Annexure A of 27701 in case of PII controllers and Annexure B of 27701 in case of PII processors with the objective that no necessary controls are omitted, especially those protecting PIIs. Of course, 27001 Annexure A you have to follow, but additional controls are there for PII controllers, Annexure A and PII processors, Annexure B in ISO 27701. So when you're making a risk treatment plan, you have to refer to all the three annexures, that is Annexure A of 27001 and Annexure A and B of 27701 standards. Next, same methodology of risk treatment. It can be avoided, it can be accepted, it can be transferred, or it can be mitigated. So, but whatever methodology you use, it should be consistent for both information security controls as well as privacy controls. Next. So here also you make a statement of applicability. So this statement of applicability includes the security controls from ISO 27001 and the applicable privacy controls of 27701 plus any other controls if they are considered appropriate. So, and this statement applicability has to be periodically reviewed and updated also whenever there are certain changes as you are doing for 27001. So statement applicability here also you have to make, but you have to add additional privacy controls of 27701 and any other controls which you consider appropriate. And it has to be periodically revised and updated also whenever this, as per your change management process. So like information security objectives, here also you make objectives and planning to achieve them. Organization shall establish information security and privacy objectives at relevant functions and levels, and there should be plans for achievement of objectives like the methodology, what will be done, who will be responsible, the resources, when the objectives will be completed, and these objectives have to be documented, and their monitoring or is required for with respect to the achievement. So objectives and planning to achieve them. So you need to formulate objectives by including privacy objectives also. And you have to make a roadmap for achievement of those objectives. That is what will be done, who will be responsible, what resources are required, when the objectives will be completed. And this is a documented requirement and you have to monitor the achievement of your objectives also. Next, so in case of support, no specific privacy addition, the requirement of 27001 apply. So no specific privacy additions. Next, then resources. Top management should provide the resources which are required for establishment, implementation, maintenance, and improvement of the management system. So that is one of the key responsibilities of top management. So they have to provide the resources also, which is extended to your privacy objectives also. Next, then there is a competence requirement. Same requirement as it is there in the other management system standards also, for example, in ISMS. So identify competence needs, then ensure that people have the desired competence, and you need to maintain the documented evidence or record of competence. So competence can be on the basis of education, training, and experience. Next, so followed by competence, awareness should be there. awareness is meant to ensure that people in the organization understand the importance of complying with security and privacy requirements, the potential impact of data breach, and how everyone contributes to the management system. So awareness, the requirements includes people in the organization understand importance of complying with security and privacy requirements, the potential impact of data breach, and how everyone contributes to the management system. So competence followed by awareness. Next, and then communication, both external and internal communication. Internal communication within the organization. So your company staff should be informed about the privacy aspects, the risk assessment, risk treatment plan, policy, and related internal communication. And external communication, when you're dealing with your external resources, you're dealing with regulatory bodies, your customers, PI principals, business authorities, partners, authorities, etc. So the requirement of external and communication processes of ISMS is extended to privacy management also. So both internal and external communication are applicable. Next, so documented information, like all other management systems, there is requirement of procedures, policies, manual, regulations, etc. So these requirements of ISO 27001, which are mentioned in 7.5.1, they are applicable here also. So mandatory documents include risk assessment, statement of applicability, privacy and information security policy, objectives, your management system scopes, and other documents which are required for effective implementation of your PIMS, that is procedures, policies, formats, various plans, etc. Next, and when you have this documented information, you need to have desired controls also, like applicable in all other management system. That is, you need to have proper format, reviewing and approving authority, how you control the distribution of documents, how you protect the documents, how the change management is done with respect to the revision of documents, what is the retention period of documents, and how the final disposition of documents is done. So control for documented information, as it is applicable in other management system standard, it is applicable in PIMS also. So you need a proper format, review and approval methodology, distribution, protection, revision of documents as per the change management procedure policy, then retention of records and policy documents, and disposition of documents and records once their useful life is over. So that is all part of control for documented information. Next. So operations, that is operational planning and control. So no specific privacy additions are there. So whatever requirements of mentioned in 27001 that apply here. So that means you need to implement the risk treatment plan, keep your risk assessment up to date, and plan and control changes as per your change management procedure. Then performance evaluation, no specific privacy addition, the requirement of 27001 apply. So that means you need to identify, determine what to monitor and measure and who is responsible, and you need to maintain the respective responsibilities. So this performance evaluation includes monitoring, measurement, evaluation, analysis and evaluation, internal audit, and management review. Next. So you need to conduct internal audit as part of compliance to ISO 27701 also. So we have towards the end of the presentation, we have slides related to internal auditing. So there we will discuss the same in details. And the requirement is that you need to conduct internal audit at planned intervals. Planned intervals, you can decide the frequency. So you need to have an internal audit program. And for each internal audit document, an audit plan is required, which includes scope, criteria, objectives. And you also have to consider the competence and objectivity of auditors. Document the findings and conclusions in the audit report. So we have a detailed session on internal audit towards the end of this program, today's session. So the requirement is that you have to conduct internal audits at planned intervals. You need to have an established internal audit program. You need to prepare an audit plan. You need to consider the competence and objectivity of the auditors, and various methodology related to the auditing process have to be followed. And finally, you need to document the findings and conclusions in the audit report. And finally, you need to do a management review. Next slide. So management review, next slide. So management reviews have to be conducted again at the planned intervals. So this includes participation from top management and also those who are responsible for implementation of management system and considering the different positions. And there has to be meeting input and output. So basically the requirements of the standard 27001 which are mentioned in 9.3 have to be mentioned along with the interpretation which is specified in clause 5.1. Next, then finally clause 5.8 is about improvement. So no specific privacy additions are there. So requirements which are mentioned in 27001 they apply. So improvement basically considers your non-conformity and corrective actions and also the continual improvement part. So non-fulfillment, non-conformity and non-fulfillment of requirement. So you need to identify the non-conformities which exist in the system. You have to react to control the non-conformity and deal with the consequences. So basically you have to do a root cause analysis or why analysis and then take appropriate actions, corrective actions. So you need to take a correction as well as corrective action to ensure that a similar situation does not happen again. So non-conformity, identification of non-conformity, taking actions to remove the non-conformity and the causes. That means a root cause analysis, why analysis, or whatever methodology you use. Then you need to do an immediate correction and also take corrective action so that the problem is not repeated again or the non-conformity is not repeated again.
Yes. So now there is a workshop after this clause. Sagar, can you share the barcode on the screen and also share the link in the chat box as well?
We have
Yeah.
given some request on the chat box
Yes,
regarding.
I am just checking the request. So yeah, you have requested for the preparation for the next quiz. Kindly share the reference material. Mr. Dr. Santosh Rane, we don't have any additional training material for the workshop. Actually, these workshops are provided after we completed the every clause by clause. So after every clause, we are just prepared a workshop to just you can say your increase your engagement or to get awareness and checking that how attentive you are attending the training sessions and how and what you are understanding from the you can say training after each and every clause, right? And regarding the criteria for getting the certification after this training session, definitely we will be sharing this training which we are presenting, training PPT. We will be sharing the training PPT with you via mail, right? And the criteria for getting the certification will be, Sagar, can you confirm it is 50% or 70% marks? Sagar, can you confirm?
It is 50%.
50%. Thank you, Sagar. So, Mr. Rane, basically the qualifying criteria is the 50% marks. I think the total marks is 40 marks marks and you or any of the participant who will be getting 20 marks or 50% or above 50% will be getting the certification for internal audit training.
So quiz will be also considered in that evaluation?
No, sir. These questions or workshops are not considered for the evaluation. These workshops are provided just to make this training session more interactive and increase your engagement.
And
for the
the
training.
evaluation is purely based on the examination at the end?
Yes, purely on the examination only. Yes.
Okay, fine. Thank you.
All right, sir. Thank you.
Thank you.
Yeah, so we have received many of the responses for this workshop. So Mr. Devadeep Ghosh has submitted, congratulations. Mr. B. Krishna Kumar submitted, congratulations, Mr. Kumar. Mr. Yatish Kumar submitted, congratulations, Mr. Yatish. M. Siva Teja Praneet submitted, congratulations, Mr. Praneet. Then Mr. Lakshmi Narayan Sharma submitted, congratulations, Lakshmi ji. So we have received 11 responses. Now we are going with the stats. The first question for this workshop, what does clause 5.1 of ISO IEC 27701-2019 emphasize regarding ISO IEC 27001? And the right answer for this question, extending information security to include information security and privacy. And the right answer for the percentage for this question is 100%. All the answer we received are correct answers. Next, please. Yeah, second question. In clause 5.2, understanding the context of the organization must include which additional consideration under ISO IEC 27701? And the right answer for this question, role as PII controller or processor. And again, for this question, we have received 100% answers, correct ones. So this shows basically you are very much actively and attentively attending the training session, and also your participation for this workshop is very appreciable. Next, please, Sagar, and congratulations to all. Third question, which of the following is a PIMS specific requirement under leadership clause 5.3? And right answer is assigning responsibilities for securing PII within the leadership team. And for this question, we have received correct answer percentage is 83. Again, congratulations to all. Next, please. Fourth question, what does clause 5.4 on planning require in the context of privacy? And right answer for this question, considering risks and opportunities related to PII processings. And for this question, again, we have received 100% answers are the correct answers. Again, I appreciate your participation and congratulations to all who have correctly submitted their responses. Last question, fifth question. Under clause 5.8, improvement organization must. The right answer, continuously improve the PIMS and address non-conformities. And again, for this question, we have received 100% answer are the correct answers. So from bottom of my head, I again congratulate to all participants and thank you for your actively participation. Now I request Atul Suri sir to resume the training session.
So now we discuss clause number 6, which are PIMS specific guidance related to 27002. So basically, there are 15 subclauses, 6.1 to 6.14. So we will take these one by one. So 6.1 is general, 6.2 is information security policies, 6.3 is organization of information security, 6.4 is human resource security, 6.5 is asset management, 6.6 is asset control, access control, 6.7 is cryptography, 6.8 is physical and environmental security, 6.9 is operations security, 6.10 communication security, 6.11 system acquisition, development and maintenance, 6.12 supplier relationships, 6.13 information security incident management, 6.14 information security aspects of business continuity management, and 6.15 compliance. So we had seen in one previous slide, except 6.14, there are additional requirements with respect to privacy aspects, privacy management in all other, that means in 6.1 to 6.15, except 6.14, there are additional requirements. Okay, next slide. So the guidance in general 6.1, guidelines in 27002 that mention information security must be extended to include protection of privacy, specifically in context of processing of PII, personal identifiable information. So wherever information security word appears in 27002, you have to read it as information security and privacy, and your control objectives and controls need to address security risks as well as privacy risks related to PII processing. So 6.1 is general. It says that wherever information security appears in 27002, you need to change it to information security.
हा सर, ते लीडरशिप ट्रेनिंग रिलेटेड तुम्ही जे ऍडवाइस केलं होतं तर त्याची डेट काय एक्झॅक्ट कळू शकते का मला?
So information security, wherever it appears in 27002, you need to read it as information security and privacy, and your control objectives and controls need to address security risks as well as privacy risks, because basically it's an extension of 27001 or 27002 as applicable. Next, then comes your information security and privacy policies. So earlier it was information security policies. Now these are policies for information security and privacy. So the purpose is to provide management direction and support for information security and policy. So this can be done through separate privacy policies or augmented information security policies. So in addition to information security, you need to address the privacy policies also. So either you can have a separate privacy policies, or you can modify your existing information security policies to add privacy aspects also. So supported by lower level policies that must also address the processing of PII, for example, mobile devices, access control, cryptography, backup, etc. So you need to update your policies, and you need to have a policies for information security as well as privacy policies. So either by development of separate privacy policies or by augmentation of information security policies, the organization should produce a statement concerning support for and commitment to achieving compliance with applicable PII protection legislation and or regulation, and with the contractual terms which are agreed with the organization and its partners, its subcontractors, and its applicable third parties, that is customers, suppliers, etc., and which should clearly allocate responsibilities between them. So basically, you need to consider your applicable PII protection legislation, regulation, also during the development and maintenance of information security policies. So either augment your existing information security policies or make separate privacy policies so that your policies are updated for privacy aspect also. That means your policies now become information security and privacy policies. And these policies have to be periodically reviewed and updated also, as you are reviewing and updating your other policies, information security policies. So update the policies, make separate privacy policies, or augment the existing policies, security policies, so as to add privacy part also. So the organization should formally state its support and commitment to compliance with PII protection laws and regulations, and adherence to contractual obligations with partners, subcontractors, and third parties, that is customers, suppliers, etc. And these policies have to be periodically reviewed and updated. And you need to ensure alignment with evolving PII protection legislation and organizational rules. For example, once you are implementing DPDP rules, so you need to update your policies in accordance with the requirement of those act and rules also. Or if you are implementing GDPR, now this GDPR act has rules have become applicable for you. In that case, you need to update your policies and procedures. So ensure alignment with evolving PAI protection legislation and organizational roles, because organizational role can also change. You can be a controller or processor or joint controller. So you have to review your policies and update these policies periodically as per your change management procedure. Organization of information security and privacy, internal organization. So one or more persons shall be responsible for privacy related issues, for example, data protection officer, or it can be outsourced also. So requirement is independent, that is sufficient independence to perform the task. Then expertise is required in data protection legislation and be involved in PII processing related issues, and needs to have responsibility for informing the top management and employees on their obligation and communication with the authorities. So organization of information security and privacy, internal organization, you need to define and allocate roles and responsibilities relevant for information security and privacy and segregate the conflicting duties. So what is required is, additional requirement in this case is the organization should designate a point of contact for use by the customer regarding the processing of PII. So whenever the organization is a PII controller, you need to designate a point of contact for PII principals regarding the processing of their PII. So this person's responsibilities have to be defined. So that responsible person, wherever appropriate, he or she should be independent and report directly to the appropriate management level of the organization in order to ensure that effective management of privacy risk can be done. And this person has to be involved in the management of all issues which relate to the processing of PII, and expertise is also required. So he or she has to be expert in data protection legislation, regulation, and the practices. And the individual acts as a contact point for various supervisory authorities also. And he or she also has the responsibility of informing the top management and also the employees the organization of their obligation with respect to the processing of PIIs. And wherever privacy impact assessment is carried out, so he or she has to be part of that also and provide the necessary advice or expertise. So you can even call him as a data protection officer. So though data protection officer becomes a mandatory requirement as per the applicable act or rules. So otherwise also you can nominate that person as a DPO. So same thing, information security roles and responsibilities. The organizations must appoint a designated contact for handling PI related inquiries, and for PI controllers, a contact for PI principal, that is data subjects, and for general use, a contact for customer or external parties. So you have to assign responsibilities to individuals to develop, implement, and maintain a privacy governance program, and also comply with the applicable privacy laws and regulations. So the person whom you have given the responsibilities or the designated person, he or she should act independently, reporting directly to the senior management. So he or she has to manage all PIA processing related matters, has to be an expert in data protection law and practices, and has to serve as a point of contact for supervisory authorities. And responsibilities also include educating employees and top management on PI related obligations, because the penalty is huge. Even if in case of DPDP Act, the non-compliance penalty can be in hundreds of crores of rupees. So you cannot afford to have any violations to your PII related obligations. So educating employees and also the involvement and briefing the top management is quite essential requirement. And wherever you are doing privacy impact assessment, he or she has to play a key role in providing the necessary guidance and ensuring that the document is useful and meaningful. So you can also call that individual as data protection officer in case it is a mandate as per the law. Segregation of duties, avoid a single person having total control and prevent conflict of interest. So just a common sense that do not give all responsibilities to a single individual. So segregation of duties is required, and avoid a single person having total control and preventing the conflict of interest. So conflict of interest part also you have to take care. There should not be any conflict of interest. Next. So 6.3.2 additional requirements are with respect to mobile devices and teleworking. So you need to make sure that the use of mobile devices shall not lead to a compromise of PII processed, and a policy for use of mobile devices should be established. Next, teleworking also, work arrangement that allow the employees to perform work related tasks from home or from other convenient location. So you need to have a policy for teleworking or remote working, and you need to have a authorized teleworking locations. Then human resource security is also required, 6.4. So human resource security talks about screening of candidates, that is prior to employment, then terms and consider PI processing involved, then terms and conditions for employment are there, that is contractual agreements. So you need to address the confidentiality part. Then you provide training, train employees on security and privacy. Disciplinary process also has to be there, which is applicable for security and privacy breaches. Then when a person is exiting, exit interview, understand and remind the obligations, and access rights, remove the access rights after the exit once the person has left. So there are, when you consider human resource security, then there are requirements related to prior to employment, that is screening, then terms and conditions of employment, then during employment also management responsibilities, information security, awareness, education and training. Disciplinary procedures are required, and whenever there is some termination or change of employment, then employment responsibilities are also there. So this is all part of human resource security. So as a part of information security, awareness, education and training, organizations must enhance awareness and training programs to include privacy specific risk and responsibility, especially for those handling personally identifiable information. So in the organization, those who are handling your personally identified PII information, they need to be specifically given training for enhancing their awareness and training with respect to privacy specific risks and responsibilities, and also compliance to applicable legal requirements. Because if any violation is there, then the penalties are going to be huge on the organization. So training should include incident reporting awareness and consequences of privacy/security breaches, which includes for the organization legal penalties, loss of business, reputational harm is there, and there can be disciplinary action on staff members also. And for PI principles, there can be emotional, physical, or material impact. So awareness is very important part, awareness, education and training. So the organization must enhance the awareness and training programs on privacy specific responsibilities, risks and responsibilities, especially for those people, those employees who are handling personally identifiable information. So this training should include incident reporting awareness and consequences of the breaches. So what consequences can be there for PI principals, for the employees themselves, or for the organization, which can be in terms of huge penalties, business loss, and reputational harm. And for staff members, employees also, disciplinary action can be there. So all that had to be covered adequately in the awareness, education, and training part. Then asset management, inventory of assets. Asset is anything that has value to the organization. So what is covered under asset management? Next. So asset ownership and acceptable use asset should be owned. So the purpose of ownership is assign responsibility for protecting the assets and acceptable use policy. So asset management includes responsibility for assets, that is the inventory of assets, ownership of assets, and acceptable use of assets. And finally, return of assets also. So acceptable use policy has to be there for assets, asset ownership and acceptable use asset should be owned. Then information classification, like you are doing in ISO 27001 also. Information classification and labeling, the organization should develop an information classification scheme. So PIIs should be explicitly included in the classification scheme because you already have a classification scheme in ISMS. So you should also include PII in that classification scheme. So classification done on the basis of like confidential, restricted, internal use, and public. So labeling information also has to be there. So this classification controls. So basically you need to have the control implementation and guidance which is mentioned in ISO 27002 2013 clause number 8.2.1, and then you need to have some additional controls with respect to PII. So organization's information classification system should explicitly consider PII as part of the scheme it implements. So this consideration of PII within the overall classification system is integral to understanding what PII the organization processes, for example, the type and categories, and where such PII is stored and systems through which it can flow. And then you need to do a labeling of information also. So you have to follow the controls which are mentioned in 27002 clause 8.2.2 and additional controls for your PII. So organization should ensure that people under its control are made aware of the definition of PII and how to recognize that information that is a PII. And then finally, handling of assets also. Handling of assets. So whatever controls are there in 27002 2013 clause 8.2.3, those controls apply. So the important thing is that in your information classification and labeling, you need to consider PII also. So as we have discussed the additional requirement, just 1 minute, yeah. 6.5.2.1 classification of information, additional requirement is organization's information classification system must explicitly include PII, that is personally identifiable information. This then integrate PII classification into overall data classification scheme, which helps you to identify what type of PII are being processed for example, sensitive, financial, biometric, etc., where the PII is stored and which system it flows through. Next. Then you need to do the labeling also, labeling of information, that is an additional requirement. Organization must ensure that all personnel under its control understand the definition of PII and can identify and label information that qualifies as PII. So media handling, clause 6.5.3, controls for removable media if used for storing or transferring PII. So the management of removable PII, the management of removable media. So the requirements which are mentioned in ISO 27002 clause 8.3.1, and then you need to have additional guidelines also. So control for removable media if used for storing or transferring PII, and document all use of removable media or devices used to store the PII, and prefer encrypted physical media oblique devices for PII storage, and use encrypted media only when it is unavoidable, that is apply compensating controls, tamper evident packaging, and removable media which is taken outside the organization is prone to loss, damage, or unauthorized access. So encryption adds a critical layer of protection for PII. So controls which are mentioned in 8.3.1 in 27002, they need to be implemented and they need to be extended for PIA also. So organization should document any use of removable media and or devices for the storage of PIA. Wherever feasible, the organization should use removable physical media and or devices that permit encryption when storing the PII, and these encrypted media should only be used wherever it is unavoidable, and in instances where unencrypted media and or devices are used. So organization should implement procedures and compensating controls, for example, tamper-proof packaging to mitigate the risk to the PII. And wherever some removable media is taken outside the physical confines of the organization, which is prone to loss, damage, and inappropriate access, so you can consider encrypting that removable media so that a additional layer of protection for PII is there, so which reduces the security and privacy risk related to when this removable media is compromised. And then disposal of media, there are additional requirements. Disposal of media, the basic requirements are mentioned in clause 8.3.2 of 27002, and additional guidelines apply. So additional requirements are when removable media containing PII is disposed of, so organization must implement secure disposal procedures and ensure that previously stored PII is unrecoverable and inaccessible. So you need to have a documentation for that. Disposal procedure should be there, which include organization's documented information, and these procedures must be executed consistently, and these can be verified through audit also. Then there are additional requirements for physical media transfer also. When physical media containing PII is transferred, that is incoming or outgoing, so organizations must implement a tracking system to log. So basically you need to maintain a log or record to log the type of media, the sender and recipient, that is the authorized parties for this media transfer, and date and time of transfer, and number of physical media units. So basically you need to maintain a proper log for that whenever physical media transfer is there. So requirements are same, but then you have to extend it to your PII also, additional requirements. Otherwise you need to follow 27002 8.3.3 with the additional guidelines which applies for your media which is transferred, physical media transfer. So use security measures like use encryption wherever possible to protect the data, and data must be accessible only at the destination and not in the transit, and physical media should not leave the premises without authorization procedures and controls ensuring only authorized personnel can access the PII. Next. So access control also, access control policy. So the requirements which are mentioned in ISO 27002 9.1.1 apply, and additionally access control policy, principles, for example, need to know, need to use, and provide access rights, which includes the privilege rights, and remove the access. So you need to properly implement the access control policy. So as a part of this user access management, you need to have a user registration and deregistration process. So additional requirements are organizations must ensure that user registration, deregistration procedures cover systems and services that process the PII, and these procedures address situations such as user account compromise, inadvertent disclosure of registration credentials, and corruption or loss of user control. So basically, user registration and deregistration, you need to follow 27002 clause 9.2.1 and additional requirements, additional guidance. That means procedure for registration and deregistration of users who administer or operate systems and services which process PII should address the situation where user access control for those users is compromised, such as the corruption or compromise of passwords or other user registration data, for example, as a result of inadvertent disclosure. So the organization should not reissue to users any deactivated or expired user IDs for systems and services which processes the PII. And in case their organization is providing PII processing as a service, then customer can be responsible for some or all aspects of user ID management, and such cases should be included in the documented information. So that should be recorded. And some jurisdiction impose specific requirements regarding the frequency of checks for unused authentication credentials related to systems which process PII. So organizations operating in these jurisdictions should take compliance with those requirements also into account. So these are the additional requirements related to user registration and deregistration. Then user access provisioning. There are additional requirements, security and enforcement, that is deactivated or expired user IDs must not be reused or systems handling PII. Only registered authorized users should have access to system processing personal data. For PII processing services, if PII processing is offered as a service, the customer may manage user IDs, and in such cases, responsibilities must be clearly outlined in the documented agreement. And jurisdictional compliance, some regions may require some regular checks for unused credentials also, and organizations must ensure that local legal compliance for PII related user systems is followed. User access provisioning, so organizations must maintain accurate, up-to-date record of user profiles authorized to access systems processing PII, and these user profiles should include user ID, associated access rights, and technical controls in place for access authorizations. So that is part of user access provisioning. Next, the purpose of individual access IDs ensure systems can identify who access the PII and track what actions were performed, that is addition, deletion, or modification, and supports accountability and security auditing. Next, PII processing as a service. If the organization provides PII processing as a service, then customer may manage the access. The organization must offer tools to assign, manage, or revoke access as required. So privileged access rights can be restricted or automatic expiration or assigned to a different user ID or granted by the asset controller. So secure logon procedures, additional requirements. When requested by customer, the organization must provide secure logon capabilities for any user accounts under the customer's control. So you need to ensure that systems handling PII accessed by customer managed accounts are protected using authentication controls, access validation mechanisms, and secure login protocols. Then password protection. Define the process to generate passwords, educate the users, and verify the user's identity. Then utility programs and access to source codes. So wherever utility programs are there, limit their use, and access to secure code, restrict access to secure code of programs. Next. So clause 6.7 is about cryptography. So cryptographic controls are required. So the controls which are mentioned in 27002 10.1.1, and then you need to have additional controls Cryptography, the decision to use cryptography for PII protection should be in line with the results of privacy impact assessment. So the input for the cryptography process is when you have done the privacy impact assessment and you have identified what kind of risks there are there and what kind of risk mitigation measures can be there. So you need to have a policy, document a policy on use of cryptographic controls. Then you need to inform the customer also, and you need to have key management, that is control cryptographic controls from generation to the destruction part. So clause 6.7 addresses cryptography with additional controls. So some jurisdictions can require the use of cryptography to protect particular type of PIIs, such as in case of health data or some residential registration number or passport number or driver's license number. So you should provide information to the customer regarding the circumstances in which it uses cryptography to protect the PII it processes. So the organization should provide information to the customer about any capabilities it provides that can assist the customer in applying their own cryptographic protection. So you need to have a cryptography policy. You need to inform the customer, update the customer also, and you need to control cryptographic keys from generation to the destruction part. So we were discussing about policy on use of cryptographic controls. So additional guidance is organizations must use cryptography to protect certain type of PII, for example, health data, ID number, passport data, where required by jurisdiction law. Inform customers when and how cryptographic controls are applied to protect the PII, and what capabilities are available to help customers implement their own encryption measures, and it may be mandated by law in certain regions. So you have to refer to the regulations, applicable regulations also, where cryptography is mandatory or not. So if it is mandatory, then you have to follow it. Physical and environmental security. So physical and environmental security talks about security perimeters, entry controls, external and internal controls, that is environmental threats, and delivery and loading areas. Next slide. So equipment, protect the equipment against environmental threats, position the equipment so that risks are minimized, maintain the equipment adequately. Then you need to have authorization for taking the equipment off the premises, and you need to have clear desk and clear screen policy and secure disposal policy. So basically all these controls are required in 27001 implementation also, ISMS system also, and these you need to extend it to your PII part also. So physical security parameter is there, physical entry controls are there, you need to secure offices, rooms and facilities, you need to protect against external and environmental threats, and you need to have guidelines for working in secure areas, delivery and loading areas, and for equipment proper protection is required, equipment seating and protection guidelines, cabling security, equipment maintenance, guidelines for removal of assets, security of equipment and assets premises. So basically all these requirements are there in ISMS system also, and similar requirements you have to, similar controls you need to extend for PII part also. So next slide. So utilities and cabling, supporting utilities, inspect and test supporting utilities. Cabling security you need to ensure. Cables must be protected against interception, interference and damage. See, all these controls are part of your existing ISMS also. And I once again repeat that these have to be extended to your PAI security also. Next, secure disposal or reuse of equipment, additional guidance. So organizations must ensure that when storage devices are reassigned or disposed of, any previously stored PAI must not be accessible, and technical controls must be applied to prevent unauthorized recovery of data. So risk context, deleting PII does not guarantee that it is unrecoverable. Performance limitations may prevent complete measure. So this poses a risk of unintended PII access by subsequent users. So you need to have proper policy related to securing disposal or reuse of equipment. So all these controls are already mentioned in the relevant control of ISO 27001 or 27002. Next. So implementation guidance is devices should be treated as containing PII by default and use secure disposal techniques such as cryptographic erasure, overwriting, or physical distraction, for example, shredding or degaussing. So many companies use these degaussing techniques also. So that can be considered for PII also. So basically your erasure techniques have to be or disposal techniques have to be adequate. Use secure disposal techniques such as cryptographic erasure, overwriting, or physical distraction, for example, shredding or degaussing. Then, like in case of ISMS, you have a clear disk and clear screen policy. So same is extended to PIA also. So additional guidance is organization should limit the creation of hard copy documents containing PII and only generate physical PII documents which are strictly necessary for the designed or the defined for processing purpose. The purpose of this control is prevent unauthorized access to PII left on desk or screen and reduce risk of PII exposure in shared or open work environment. So clear task and clear screen policy, this is a requirement of ISMS controls also, but this is further extended to PII controls also, that don't take the hard copy printouts, take only when it is required, necessary for some purpose. And basic idea is to prevent unauthorized access to PII left on desks or screens. And you need to reduce the risk of PII exposure in shared or open work environments. Okay, so 6.9 is operation security. So it talks about documenting the operating procedures, then control changes, that is the change management, capacity management, separate development, testing and operational environments, and protection against malware. So next slide. So 6.9.1 is operational procedures and responsibilities. We talks about documenting operating procedures, which is mentioned in 27002 12.1.1. Then it talks about change management, which is mentioned in 27002 control number 12.1.2. Then capacity management, which is mentioned in 27002 12.1.3, and separation of development, testing, and operational environments, which is mentioned in 27002 12.1.4. So same requirements are there. 6.9.2 talks about protection from malware, that is controls against malware, which is with the controls which are mentioned in 27002 12.2.1 applies. And then now we come to 6.9.3, which is backup. Come to 6.9 backup. So additional guidance is supplementary ISO 277201 requirements are document requirements for PII backup, recovery, and restoration. So backup requirement is there also, but this is extended to PII backup, recovery, and restoration. And you need to inform customers on PII backup and restoring capacity, and you need to maintain the logs of PII backup restoration. So for information backup, organization should have a policy which addresses the requirements for backup, recovery, and restoration of PII, which can be part of the overall information backup policy. And any further requirements, for example, contractual and legal requirements for erasure of PII contained in the information held for backup requirements has to be addressed. So PII specific responsibilities in this regard, they can depend on the customer as well as the applicable regulatory requirements. So organization should ensure that customers are informed of the limits of the service regarding backups. And where the organization explicitly provides backups and restores services to the customers, so then organization should provide them with clear information about their capabilities with respect to the backup and restoration of PII. And there are certain jurisdictions also which impose specific requirements regarding the frequency of backup of PII, the frequency of reviews and testing of backups, or regarding the recovery procedures for PII. So organizations which are operating in these jurisdictions, they need to demonstrate compliance with these requirements. And there can be some occasions when this PI needs to be restored due to some system malfunction or some disaster or attack or cyber attack, etc. And when this PII is restored, that is from the backup media, then your processes need to be in place to ensure that this PII is restored into a state where the integrity of PII can be assured and where this PII inaccuracy or any incompleteness is identified, and the processes are put in place to resolve them. So, which can even include following up with the PII principle. So you need to have a documented procedure for that, and you need to maintain a log of all PII restoration efforts. And so basically, when you are maintaining the record, so you need to mention the name of the person who is responsible for this restoration and also a description of the restored PII. So even in some mandatory requirements, some jurisdiction, you need to prescribe the contents of the log of the PII restoration efforts also. And any judicial requirement or any applicable legal requirement for restoration of log content, you need to maintain a record, and you need to maintain that record. And if that legal body in during their audit or even the audit of your documents, etc., you need to show that record and evidence. So backup and restore responsibility. If the organization offers backup restore services, it must clarify the capabilities and scope of PIE restoration, then identify who is responsible for backup related decisions, and you need to maintain a PIE restoration log, as I already explained, including the name of the person responsible for that and the description of the restored PII. Next, so whenever PII is restored, your system must ensure the integrity of PII data, and you need to trigger processes to notify and resolve issues involving PII or its principles. Then, as I already explained, event logging is an additional requirement. Organizations must establish a process to review event log for system handling PII using automated monitoring or and alerting or manual review at scheduled intervals. So what kind of records are to be maintained if PII is involved in the event log? That who assessed the data, when and which PII principles data was accessed, what changes, that is addition, deletion, modifications were made, the reason for the event if applicable, and shared services or cloud providers should define and document roles and responsibilities between the service providers and address agreements on log access and usage rights. So logging and monitoring record is required. Produce logs and review that regularly. Keep log of access to PII. Make sure that customers have access only to logs related to their activities. Review those logs, protect those logs, and define log retention period and delete logs automatically, and use of synchronized logs. So these are the requirements related to logging and monitoring. Protection of log information, additional guidance. So there are controls which are mentioned in 27002, 12.4.2, and the additional guidance applies. So log information, for example, for monitoring or diagnostic may contain PII and must be protected accordingly. So you need to implement access controls to ensure that the logs are accessed only by the authorized personnel and they are used only for their intended purpose. So you need to put in place automated procedures to delete or de-identify the logs, and these are in line with the defined retention schedule. So log information recorded, for example, security monitoring and operational diagnostic can contain that PIE also, and measures such as controlling access should be put up in place to ensure that the logged information is only used as intended. And a procedure, and preferably that should be an automated one, automatic, should be put in place to ensure that logged information is either deleted or de-identified as specified in the retention schedule. Next is control of operation security. So control software installation and be informed on the vulnerabilities. So when you're talking about control of operational software, so installation of software on operational systems, the guidelines are already given in 27002, 12.5.1. Those guidelines apply. And then you also need to have a technical vulnerability management also. So guidelines are there in 12.6.1 of 27002. And what kind of restriction is there on software installation? So those guidelines are given in 12.6.2. And this information security or audit considerations also you need to consider, which are mentioned in 12.7.1. So all this is part of operational security, but basically the guidelines which are given in 12.6.1, 12.6.2 and 12.7.1 of 27002 apply. Communication security. So network security management. network controls, procedures, responsibilities, activity monitoring, access restriction, and agree service and security levels with the suppliers and monitor their services. Network segregation, that is segmentation, and monitor the effectiveness of controls implemented. So basically, the guidelines for network controls, they are given in 27002 13.1.1. So those guidelines apply. Then the security in network services, the guidelines are mentioned in 27002 clause 13.1.2. So those requirements apply. And then segregation in networks also, requirements which are mentioned in 27002 13.1.3, those requirements apply. So communication security is basically about network security management. So your network controls, procedures, responsibilities, activity monitoring, network segregation, and you need to monitor the effectiveness of controls. Information transfer, maintain the security and privacy of information exchange inside the organization and within the external parties. So you need to have policies and procedures for information exchange. Then you need to have agreements on the information transfer, electronic messaging, confidentiality, and non-disclosure agreements. So if you refer to 27002, there are controls. Controls information transfer policies and procedures are addressed in 13.2.1 of 27002. And when you are referring to that, so organization should consider procedures for ensuring that rules relating to processing of PIA are also enforced throughout and outside of the system where applicable. So you need to have policies and procedures for information exchange. Then you need to have agreements for information transfer. So these are addressed in 27002 13.2.2 clause number. And electronic messaging is also addressed in 13.2.3 of 27002. And confidentiality and non-disclosure agreements are addressed in 13.2.4 of 27002. And additional guidance for that is that organization should ensure that individuals operating under its control with access to PII are subject to a confidentiality obligation. So this confidentiality agreement, whether it is part of contract or separate, should specify the length of time the obligation should be adhered to. And when the organization is a PII's processor, confidentiality agreement in whatever form between the organization, its employees, and its agents should ensure that employees and agents comply with the policy and procedures concerning the data handling and protection. So information transfer talks about policies and procedures for information exchange, agreements on information transfer, electronic messaging, and confidentiality and non-disclosure agreements. So as we discussed, organizations should define procedures to ensure that PIA processing rules are enforced both within and outside the system where applicable, and it applies to any form of data movement that is internal, external, automated, or manual. Next, confidentiality or non-disclosure additional guidance. All individuals under organization's control with access to PII must be bound by confidentiality obligation, and the agreement should specify the duration of the obligation. And for PII processes, organization must ensure that employees and agents comply with internal policies and procedures regarding data handling and protection. Next. So 6.11 is system acquisition, development and maintenance. So there are security and privacy requirements to be considered in acquisition of new systems and enhancement of existing ones. Then information on public networks, that is protect the information transmitted through public networks, also internet. So PIE should be encrypted. And software development, document and apply a secure development policy, privacy by design and privacy by default. So we are talking about privacy by design and privacy by default. So next, so control changes, modification to software packages and software testing. So control changes to the software development process shall be controlled. Modification to software packages, the organization should restrict modification to the vendor supplied software. And software testing, avoid using PII for software testing purpose. So these are the guidelines with respect to system acquisition, development and maintenance, which are mentioned in 27701. So primarily guidance on security requirements, it is mentioned in 27002 clause 14.1.1. Then security application services on public networks. The requirements are mentioned in 14.1.2. And additional requirement is that organization should ensure that PI that is transmitted over untrusted data transmission networks is encrypted for transmission, and untrusted networks can include the public network and other facilities outside the operational control of the organization. So organization must ensure that PII transmitted over untested networks is encrypted during transmission, and these include the public internet and any external network which is not under organization's operational control. So secure development policy, the additional guidance is development policies must incorporate privacy by design and privacy by default principles, ensuring that PII protection is embedded into system design and development processes. The design addresses obligations to PII principles and complies with applicable legal regulatory requirements. So basic guidelines are given in 14 ISO 27002, clause number 14.1.3. Then secure development policy is mentioned in clause 14.2.1, and there are additional controls which are required. So policies for system development and design should include guidance for organizations processing of PII needs based on obligations to PII principles and or the applicable legislation regulations and the type of processing which is performed by the organization. So policies which contribute to privacy by design and privacy by default should consider various aspects like guidance on PII protection and implementation on privacy principles, which are referred in ISO IC 29100 in software development lifecycle, and then privacy and PII protection requirements in the design phase, which can be based on the output from a privacy risk assessment or privacy impact assessment exercise. Then you also need to have PII protection checkpoints within the project milestones and required PII and privacy protection knowledge, and you need to ensure that by default minimize the processing of PII. So further requirements are also mentioned in the control change procedures, which is there in clause 14.2.2 and 14.2.3, 14.2.4 and 14.2.5. So all this is part of secure development policy. Next. So your development policy should address PII protection guidance and implementation of privacy principles throughout the software development lifecycle, SDLC. SDLC is software development lifecycle. And PII risk assessment output and privacy impact assessment inputs during the design, PII protection checkpoints aligned with the project milestones, the required privacy and PII knowledge for development teams, and design approach which minimizes PII processing by default. Next. So the key requirement is systems and components related to PII processing must be designed with privacy by design and privacy by default, and facilitation of controls for PII controllers and PII processors, which are mentioned respectively in clause number 7 and 8, which we will discuss post lunch. Design objective is ensure that PII collection and processing is purpose limited, minimized to necessity, and compliant with privacy impact analysis. And if required by jurisdiction, systems must automatically delete PII after the defined retention period and be designed to support the automated deletion. Some part of development can be outsourced also. Outsourced development, additional guidance is when outsourcing development, organizations must apply the principles of privacy by design and privacy by default. So these principles must be embedded into the outsourced systems, just as they would be in the internal development. And basically, it ensures that third-party developers also uphold privacy expectation and legal requirements protecting PII even outside the organization's direct control. So outsourcing is allowed, but outsourcing controls you need to follow. So those controls, they are mentioned in secure development, outsourced development part, they are mentioned in clause 14.2.7 of 27002, IS 27002, and these controls, same principles of privacy by design and privacy by default should be applied, if applicable, to outsourced information systems also. Protection of test data, additional guidance is PI should not be used for testing purpose and organization should use false or synthetic PI instead. So the key requirement is you should not, for software testing purpose, you should never use PI data, and you can use the false or synthetic PII instead. And if you are using real PI for testing, only if unavoidable, implement technical and organizational controls which are equivalent to those used in the production. And you also need to have a risk assessment to identify and apply suitable mitigating measures. So additional requirement for protection of test data is that PI should never be used for testing purpose and you should use false or synthetic PI instead. But in case you are using real PI data for testing, only if it is unavoidable, then you need to have appropriate technical and organizational controls which are equivalent to those which you are using in the actual production stage, and you need to have a proper risk assessment to identify what can go wrong and what can be the risk treatment plan and measures and apply suitable mitigating measures. Then supplier relationship also, because some part is outsourced, suppliers can have a significant impact on security and privacy. So you need to have a supplier management policy, security and privacy policy applicable for supplier relationships. Then your contracts with suppliers include in contracts security and privacy requirements in the supply chain. Ask suppliers to propagate security and privacy requirements because supplier may further be outsourcing something. So ask your suppliers to propagate security and privacy requirements, and then you also need to monitor your supplier performance and make the necessary changes and do the desired monitoring and measurement. Next. So those controls, basically they are addressed in 27002, 15.51.1 and 15.1.2, and additional measures are mentioned in 27701. So which says organization must define in supplier agreements whether PII is processed, the technical and organizational security measures the supplier must implement, and the requirements that align with organization's information security and protection obligations, which are mentioned in clauses 7.2.6 and 8.2.1. So the additional requirement for addressing security within the supplier agreement is that the organization should specify in agreement with suppliers whether PIA is processed and the minimum technical and organizational measures which the supplier needs to have in order to for the organization so that its information security and PII protection obligations are properly met. And supplier agreement should clearly allocate responsibilities between the organization, its partners, its suppliers, and its applicable third parties, for example, customers, suppliers, etc., taking into account the type of PIA is processed. The agreement between the organization and its suppliers should also provide a mechanism for ensuring that the organization supports and manages compliance with all applicable legislation regulation, and the agreement should also call for independently audited compliance acceptable to the customer. So these are the additional things which you need to take care when you are outsourcing activity, and you need to address those in the supplier agreements. So supplier agreement should cover allocation of responsibilities across the organization, its partners, suppliers, third parties, the mechanisms to ensure compliance with legal and regulatory requirements, the provision for independent audits and evidence of compliance, and the contracts with suppliers must explicitly state that the PIA shall be processed only as per the organization's instructions. Next, then incident management. So if you refer to 27002, incident management guidelines are given in clause 16.1.1. And additionally, what you need to have is procedure to prepare and deal with the incidents, the responsibilities for incident management, the training and awareness, access events, respond to events, identify source, and learning from the incidents. So as a part of overall information security incident management process, the organization should establish responsibilities and procedures for identification and recording of breaches of PIA also. Additionally, organization should establish responsibilities and procedures related to notification to required parties of PI breaches, including the timing of such notification and the disclosure to authorities, taking into account applicable legal requirements. So, certain jurisdictions, certain regulations, and certain acts and rules, they impose specific regulations regarding breach responses, including notification, and organizations operating in these jurisdictions should ensure that they can demonstrate compliance with those regulations. So incident management is extended to PIA also. So you need to have procedures to deal with the incidents, allocated responsibilities for incident management, the desired training and awareness. You need to assess the events, respond to incidents, identify the sources, and lessons learned from the incidents. So the guidelines, general guidelines are given in 27002, 16.1.1 and 16.1.2, reporting about information security weaknesses addressed in 16.1.3, and assessment and decision on information security events is addressed in 16.1.4. Response to information security incidents is mentioned in 16.1.5 of 27002, and this is to be extended for the PIA part also. So PIA breach, any incident that leads to access to PIA, legislation may require PIA breach notification to the relevant authorities, to the PIA principals, and to the customer also. So some countries have their specific breach response procedures, including mandatory notification within a specified time frame and demonstrated compliance readiness also. So responsibilities and procedures are there. Additional guidance as part of incident management process. Organizations must define responsibilities and procedures for identifying and recording the breaches involving the PIA and notifying the affected parties and authorities of such breaches. Next, so you have to deal with the incident, maintain the record of incident. Incident report must include description and consequences, the time, who reported to whom, what has been done, the related notification, and the consequences, with the objective of learning from incidents. Next, so response to information security incidents, implementation guidance for PII controllers. Any incident involving PII must trigger a review to determine if it constitutes a PII breach. If a breach has occurred, the response should include clear notification and record keeping and follow jurisdictional rules on timing and authority notification. Next, notification should include contact point for details, the description and likely consequences, the scope of the breach, that is record and individuals, the steps taken or planned to resolve, and the status of PII, whether it is lost, disclosed, altered, or unavailable. Then implementation guidance for PII processes. Breach notification duties should be defined in the contracts. PIE processes must notify controllers without undue delay, and the contracts must define notification process, the information provided to controllers, and the timeliness for the notification. Then in case of breach, keep record with similar details as PIE controllers. Ensure that customer is notified if PII is compromised, and in some jurisdiction, processors may need to notify the regulatory bodies directly. Next, then clause number 6.14 of 27701 talks about information security and privacy aspects of business continuity. So business continuity, there is a separate ISO standard, ISO 22301. So you need to refer to that. Business continuity, information and privacy aspects should be integrated into the business continuity arrangements. So this talks about business impact analysis, plans, procedures, responsibilities, testing, and improvement. So the further details are mentioned in 27002, clause number 17.1, 17.1.1, 17.1.2, and 17.1.3. So this talks about planning information security continuity, implementing the information security continuity, and verification, renewal, and evaluation of information security continuity. So Business continuity management system, there is a separate standard ISO 222301. Next, so compliance. So you need to identify the requirements which organizations can comply. For example, legislation, contractual requirements, etc. So there are intellectual property rights, protection of record, and cryptography. So first of all, you need to identify what legislation is applicable to you, whether it is TPDP as per Indian regulation or GDPR as per European Union or country specific regulation. So you need to identify what requirements which are mentioned in the legislation or any contractual requirement with the customer which are applicable for you. So as a part of compliance, first of all, you need to identify the requirements which you have to comply with. Next, identification of applicable legislation and contractual requirement, additional guidance. Organization must identify legal obligation and sanctions related to PII processing, which includes fines or penalties from supervisory authorities, other contractual risks due to non-compliance. So in some jurisdiction, ISO 27701 can serve as contractual framework between the organization and the customer and outlining roles and responsibilities for privacy, security, and PII protection. Next, so protection of records, organization must retain current and historical records of privacy policies, related procedures. These may be required for customer disruption resolution or regulatory investigations. So keep previous versions of documents as per the defined retention schedule. And independent review of information security when acting as PII processor or if individual customer audits are done are impractical or could increase security risks, the organization should provide independent evidence of implemented security controls. So what to provide to customers before and during auditing? Before and during the contract period, transparent, independent audit results, evidence showing compliance with internal policies and procedures, and audit conducted by a recognized body chosen by the organization. Organizations must conduct technical reviews of tools and components used for PIA processing, their compliance with security policies and standards. So that is part of technical compliance review. Next. So these review methods may include ongoing monitoring, ensure that only permitted PI processing is occurring, and penetration or validation vulnerability testing, especially on de-identified data sets, simulate attacks to validate that de-identification methods meet policy and regulatory requirements. Next. So this completes clause number 6. So now we have an exercise. And after the exercise, we'll have a 1 hour of lunch break.
Noted, sir. So now we are here for the another workshop. Sagar has already shown the barcode on the screen. Sagar, kindly share the link in the chat box. And I request all dear participants to submit responses for this workshop so that we can have the maximum responses for the workshop as well as earlier we have received. Sagar, please let me know once we receive few responses. Mr. Rahul Sharma has completed. Congratulations, Mr. Rahul. So we have started receiving the responses. Mr. B. Krishna Kumar submitted. Congratulations, Mr. B. Krishna Kumar. Mr. M. Siva Teja Praneeth submitted. Congratulations, Mr. Praneeth. Mr. Lakshmi Narayan Sharma already submitted. Congratulations, Mr. Lakshmi. Mr. Yatish, Sneha, Faizan Malik submitted. Amit Pal submitted. Congratulations to all. So now we are going for the stats. The first question for this workshop, what is the main intent of clause 6.1 general in ISO IEC 27701? And the right answer for this question, extend ISO IEC 27002 controls to include privacy and PII specific considerations. And for these questions, we have received 100% answers are the correct answers. Congratulations to all who have submitted correct answer. Next, please. Question number 2. Under clause 6.2, organizations are advised to update which of the following to address privacy? And the right answer is their information security policies. And for this question, 87% answer right answers. So again, congratulations and kudos to all who have submitted correct answer. Next, please. Third question, which of the following is an additional privacy consideration under clause 6.5 asset management? And right answer for this question, identifying and classifying PII as a part information asset. And 94% answers are the correct answers. And we have received 18 responses as so far. Congratulations to all. Next, please. Question number 4, clause 6.1.6.13 of ISO IEC 27701 relates to incident management for PII related breaches. And for this question, 66% answer are the correct answers. Again, congratulations to all submitting the correct answer. Next, please. Fifth question and last. Which clause emphasize handling supplier agreement for privacy controls and obligations? And the right answer is clause number 6.112, and 83% answer are the right answers. So I again congratulate all the participants who have actively participated and submitted their responses for this workshops and as well as for the previous workshops. So now we are resuming this training session. I request Atul Suri sir to resume the training session.
Okay, so now we start with clause number 7, additional ISO IEC 27002 guidance for PII controllers. So there are 5 subclauses 7.1, 7.2, 7.3, 7.4 and 7.5. So general requirements, then conditions for collection and processing, obligations to PII principles, privacy by design and privacy by default, and PII sharing, transfer and disclosure. So general requirement says the guidance in clause 7 and additions in this clause create PIMS specific guidance for PII controllers, and implementation guidance documented in this clause relate to controls which are listed in Annexure A. So now we come to the implementable clause, that is clause number 7.2, purpose and lawful basis. So the clause is conditions for collection and processing. So identify and document the purpose. So purpose and lawful basis, identify, document and communicate the purpose of PII processing. And PII principals must be informed clearly about the purpose of PII processing. So lawful basis, determine, document and comply with the lawful basis for PII processing. Considering the purpose identified. So lawful basis requirement says determine, document and comply with the lawful basis for PII processing considering the purpose identified, and the possible options could be consent, the performance of a contract, legal obligation, vital interest of PII principals or other natural persons, public interest task or legitimate interest. Okay, next. So first of all, you need to determine the objective for collection and processing. So determine, document that processing is lawful with legal basis as per applicable jurisdictions and with clearly defined and legitimate purpose. So what you need to do is consent, obtain and record consent. So obtain and record consent. Consent is one of the legal basis for PII processing. So document when and how consent is obtained. Freely given, that is PII principle is not pressured or influenced. Specific to the purpose of processing. Unambiguous and explicit, requires an action from the PIE principle. So organization should determine a document and process by which it can demonstrate if, when and how the consent for the processing of PII was obtained from PII principles. So the consent can be required for processing of PII unless other lawful grounds apply. So organization should clearly document when consent needs to be obtained and the requirements for obtaining consent. So it can be useful to correlate the purpose for processing with information about if and how the consent is obtained. So document when and how the consent is obtained. Some jurisdictions have specific requirements for how consent is collected and recorded. For example, not bundled with other agreements. And additionally, certain type of data collection, for example, for scientific research, for example, and certain types of PIE principles such as children can be subject to additional requirements. So the organization should take into account such requirements and document how mechanisms for consent meet those requirements. So basically you need to identify when and how the consent is obtained, and you need to obtain and record the consent. So the organization should obtain and record consent from PII principles according to the documented process. So this consent should be obtained and recorded from PII principles in such a way that it can provide on request details of the consent provided. For example, the time that consent was provided, the identification of PI principle, and the consent statement. So what needs to be ensured is that the consent should be freely given, specific regarding the purpose for processing, and unambiguous and explicit. Next. So privacy impact assessment. So detect and evaluate the risk arising from the processing of PII and implement the controls. So systematic and extensive evaluation of personal aspects that is based on automated processing, producing legal effects on PII principles, large-scale processing of special PI categories, for example, health data, the data related to racial or ethnic origin, genetic or biometric data, data about sexual orientation of natural persons, trade union membership data, political opinions, religious or philosophic beliefs, and systematic monitoring of a publicly accessible area on a large scale. So basically, PIA is the requirement. The organization should assess the need for and implement where appropriate a privacy impact assessment whenever new processing of PIA or changes to existing processing of PIA is planned. So basically, PII processing generates risk for PII principles. So these risks should be assessed through a privacy impact assessment, and certain jurisdictions define the cases for which a privacy impact assessment is mandated. So this criteria can include automated decision making, which produces legal effects on PII principles, the large scale processing of special PII categories such as health related information, racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, genetic data, biometric data, etc., or systematic monitoring of a publicly accessible area on a large scale. So, what needs to be done is that the organization should determine the elements which are required for completion of privacy impact assessment. And these can include a list of the types of PII processed and where the PI is stored and where it can be transferred. So basically what can be done is data flow diagrams and data maps can be used for this purpose. And there is a specific standard guidance on privacy impact assessment related to processing of PII. So you can refer to ISO IEC 29134 for further details. Next. So this ISO 29134-2017 gives you the methodology for privacy impact assessment. So basic steps are like setting up a team, then you prepare a plan and you describe what is being assessed, that is PII principles, purpose, assets, subcontractors, etc. Next, then you identify stakeholders and if possible obtain their feedback and information flow identification. So the aspects are collection, storage, use, transfer, and deletion. And this is with respect to the PII principal, PII controller, PII processing, or third party. So this is a methodology. For further details, you can refer to ISO IC 29134-207, which gives you the methodology for privacy impact assessment. So methodology addresses unauthorized access or modification of PII. So basically you need to identify what kind of privacy risk can be there. That is unauthorized access or modification of PII, PII theft or loss, excessive collection, inappropriate or unauthorized linking of PII, failure to consider rights of PII principles, insufficient information, change or extend processing purpose without informing PII principles, processing without the required consent, sharing PII without consent, and excessive unnecessary retention. So these are the privacy risks you have to identify as applicable, and then you need to make a risk mitigation plan. Next. So again, you use a methodology of risk assessment, analyze the risk, estimate the likelihood and impact. So This is the methodology given where you estimate the impact. The level of impact can be negligible, limited, significant, or maximum. So estimated consequences, for example, in case of negligible, PI principles are not affected at all, or there are small inconveniences that PI principles should be able to overcome without any problem. So examples are some annoyance or time spent to re-enter information into the system. And limited impact can be significant inconveniences that PIA principles should be able to overcome despite a few difficulties. And again, examples can be like denial of access to a service, additional costs, or fear or lack of understanding. Then there can be significant impact where the PI principle should be able to deal with the consequences, but serious difficulties, for example, blacklisting by banks, property damage, loss of employment, etc. And the worst category is the maximum PI principle suffer significant or irreversible consequences which they may not be able to overcome. For example, inability to work or death or long-term psychological or physical ailments. And likelihood estimation, likelihood levels are negligible, limited, significant, and maximum. So level of impact and likelihood. Likelihood estimation is estimated likelihood negligible, then it does not seem possible to happen given the controls in place. Wherever you have got effective controls, so possibility is very remote. Limited, when it appears to be difficult to happen. Significant is possible, appears to be possible, and maximum is likely to happen. So you use the risk assessment methodology, analyze the risk and estimate impact and likelihood. Next, then again, using the same methodology, you assess the risk, combine impact and likelihood, and then you categorize them overall in the categories. So basically, this is how you use the private impact assessment methodology for PAA by referring to ISO 29134-2017. Next, so then you make a risk treatment plan and focus on non-acceptable risk. And again, the methodology can be reduction, avoidance, retention, or transfer. So this overall privacy impact assessment report includes information on the organization, the compliance obligations, the scope of PIA, the purpose of PIA, who and when conducted the PIA, types of PIA collected and processed, the description of processing activities, legal jurisdiction, the methodology for PIA, threshold for non-acceptable risk, risk map, risk treatment plan, conclusions, decisions, and recommendations. So next is 7.2.6 contracts with PIA processors. So contracts, the PIA controller should sign contracts with all PIA processors it uses, and contracts should require PIA processors to implement the controls which are mentioned in ISO IEC 27701. So the requirement is that the organization should have a written contract with any PIA processor that it uses, and it should ensure that the contracts with the PIA processor addresses the implementation of the appropriate controls which are mentioned in ISO IC standard 27701. And the contract between organization and any PIA processor processing PIA or on its behalf should require the PIA processor to implement the controls which are required, taking account of the information security risk assessment processes also, and the scope of processing of PIA performed by the PIA processor. And by default, all the controls which are mentioned in Annexure B of ISO IC 27701 should be considered as relevant. And if the organization decides not to require PI processor to implement any control which is mentioned in Annexure B, then justification for exclusion should be mentioned in the documentation. And a contract can define the responsibility of each party differently, but to be consistent with the documents, all controls should be considered and included in the documented information. Then there can be a case of joint PI controller also, two or more organizations acting as PI controllers. So there can be a joint controller agreement involving the parties. Then you need to mention the purpose of data sharing, PII processing activities, the roles and responsibilities, data breach management, retention and disposal of PII, obligations to PII principals, contact point, and failure to fulfill the agreement. So all these have to be considered when you are having a case of joint PII controller. So normally it is like this. In case of joint PII controllers, the organization should determine the respective roles and responsibilities for processing of PII, which includes PII protection and security arrangements within any joint PII controller. So the roles and responsibilities for processing of PII should be determined in a transparent manner. And these roles and responsibilities should be documented in a contract or any similar kind of binding document which contains the terms and conditions for joint processing of PII. And in certain jurisdictions, such an agreement is also known as a data sharing agreement. So you can have lot of details in the joint controller agreement, which can include like purpose of PII sharing or joint PII controller relationship. Then the identity of the organizations, that is the PII controllers, which are part of that joint PII controller relationship, and what category of PII is to be shared and or to be transferred and processed under the agreement. Then you also need to have an overview of the processing operations, what kind of operations are there. Description of roles and responsibilities has to be there. Then responsibility for implementing various technical and organizational security measures for PII protection has to be adequately documented and implemented. And also the definition of responsibility in case of a data breach, PII data breach. So proper data breach management policies have to be there. For example, who will notify the regulatory bodies, when, and what kind of mutual information would be shared. Then also, what are the terms and conditions for retention and disposal of PII? What are the liabilities for failure to comply with the agreements? How the obligations to PII principals are met? And how to provide PII principals with information covering the essence of the arrangement between the joint PII controllers. And there has to be a contact point for PII controllers. And then records have to be maintained. So the organization should determine and securely maintain the necessary records in support of its obligation for processing of PII. So what kind of records? Maintain records in secure conditions. Inventory of processing activities, type, purpose, PII processed, PII principals, recipients, security, and PII. So you need to have a system of maintaining the records. A way to maintain records of processing of PIIs is to have an inventory or the list of PII processing activities within the organization that the organization is performing. And the examples include like what kind of processing is done, the purpose of that processing, a description of categories of PII and PIIs. For example, if you are handling children related PII or dependent related PII, and the categories of recipients to whom this PII has been or will be disclosed, including the recipients in third countries or international organizations, and also a general description of technical and organizational security measures. And finally, a PII assessment report, privacy impact assessment report. And this list should also have an owner, process owner, who is responsible for ensuring its accuracy and completeness. Next. So actually this is 7.3. This is a typing error. Correct it in the PPT when you are mailing to others, make it 7.3. So obligations to PII principals. So determine and fulfill obligations. Identify obligations to PII principals. Provide the means to meet the obligations. Provide a contact point to PII principals. And then determine information to PII principals, that is purpose and lawful basis, the contact, how was this PII obtained, the legal obligations, transfer and recipient of PII, the retention, automated processing, rights of PII principals and obligations of PII controller, and how a complaint can be lodged. So moving further, next. So obligations to all PI principals, providing information to PI principals. So providing information means clear and easy to access, concise, complete, and provided in a timely manner, and provide a contact point to PI principals, for example, in terms of some notice. So the organization should determine and document their legal, regulatory, and business obligations to PI principals relating to the processing of the PII and provide the means to meet these obligations. So what is to be done is obligation to PI principals and the means to support them. They vary from jurisdiction to jurisdiction, or that means country to country. So organization should ensure that they provide appropriate means to meet the obligations to PI principals in an accessible and timely manner. Then clear documentation should be provided to PI principals describing the extent to which the obligations to them are fulfilled and how, along with an up-to-date contact point where they can attach this request. So information has to be clear and easy to access, concise, and they also have to provide a contact point to the PI principals. And this contact point should be provided in a similar way to that used to collect PII and consent. For example, if PII are collected by email or a website, then the contact point should be having email or the website address and not some alternative like phone or fax. Then providing mechanisms to withdraw or modify the consent. So communicate to all PI principals, define the response time to requests, record requests, stop processing once the consent is withdrawn, and communicate requests to all parties involved, and providing mechanisms to object to PI processing. So it has to be as per the applicable legislation. So depending upon these requirements, this information can be in the form of a notice. For example, types of information which can be provided to PI principals are, that is the information about the purpose of processing, the contact detail for the PI controller or its representative, the information about the lawful basis of the processing, the information on where the PI was obtained and if not obtained directly from the PI principal, the information about whether the provision of PII is a statutory or contractual requirement, and where appropriate, the possible consequences of failure to provide PII. Then information on obligations to PI principals and how PI principals can benefit from them, especially regarding assessing, amending, correcting, requesting erasure, receiving a copy of their PII, and objecting to the processing. And information on how the PI principal can withdraw the consent, information about transfer of PII, information about recipients or categories of recipients of PII, the information about the period for which this PII will be retained, and information about use of some automated decision mechanism based on the automated process of PI processing of PII, or the information about the right to lodge a complaint and how to lodge such a complaint. Information regarding the frequency with which information is provided, for example, some just-in-time notification or organization-defined frequency. So basically, organization should provide updated information if the purpose for processing of PIR change or extended, and ultimately it has to take care of the applicable legislation. So access, correction, and/or erasers, provide information to PI principals, mechanisms for correcting PII at the request of PI principal, and allow principals to have PII deleted. And obligation to provide information to third parties. So adequate communication has to be there. Adequate allocation of responsibilities has to be there. And providing a copy of PII process upon request. So for that, you need to refer to the legislation and what format that information is to be shared. And transfer a copy of PI to other organization at the request of PI principal if possible. So handling requests, document how the requests are handled, for example, response time, charges, responsibilities, process, etc. And automated decision making, a decision based exclusively on automated means which doesn't involve any human intervention. So for that also, you need to identify the legal requirements. For example, notification of PIA principle, right to object, and requires human intervention. So privacy by design and privacy by default. So collection and processing of PIA is limited only to what is necessary for the purpose of processing. So limit collection, identify the purpose and collect only the PIA which is adequate, relevant, and necessary. And limit processing, PIA processing should be limited only to what is relevant, adequate, and necessary. And you need to take care of accuracy and quality also. So PIA processed should be accurate, complete, up to date throughout its whole life cycle. So the objective is to ensure that the processes and systems are designed such that the collection and processing, including the use, disclosure, retention, transmission, and disposal, are limited to what is necessary for the identified purpose. So what the organization should do is, it should limit the collection of PII to the minimum which is relevant, proportional, and necessary for the identified purpose, that is limit collection. And also limit processing. Organization should limit the processing of PII to what is adequate, relevant, and necessary for the identified purpose. So this includes the disclosure, the period of PII storage, and who is able to access the PI. And this should be limited by default to the minimum necessary, relevant to the identified purpose. And you also need to take care of the accuracy of quality. So the organization should ensure and document that the PII is correct, accurate, complete, and up to date, which is necessary for the purpose for which it is being processed throughout the life cycle of the PII. So organization should implement policies, procedures, mechanisms to minimize the inaccuracies in the PII it processes. And for that, there should be policies, procedures, and mechanisms to respond to the instances of inaccurate PII. And these policies, procedures, mechanisms should be included in your documented information. That means through your technical system configuration, documentation, etc. And it has to be applied throughout the life cycle of PII. And you can obtain further information on PII processing life cycle in ISO 29101-2018, referring to clause number 6.2. Then privacy by design and privacy by default, PII minimization objectives, data minimization. Processing should only use as much personal data as it needs in order to achieve the purpose. Data pseudonymization. PII cannot be attributed to a specific PII principle without additional information. So organization should define and document data minimization objectives and what mechanisms such as de-identification are used to meet these objectives. So the organization should identify how the specific PII and the amount of PII collected and processed is limited relative to the identified purposes, and this can include the use of de-identification or other data minimization techniques. And the identified purpose can require the processing of PII that has not been de-identified, in which case the organization should be able to describe such processing. So you can use data anonymization techniques. PII is irreversible altered so that the PII principle can no longer be identified directly or indirectly. And you can use other techniques like data masking, data generalization, adding noise to data. So these de-identification techniques used should be in line with the results of privacy impact assessment. So privacy impact assessment, you're defining the controls or the risk treatment plans. So they should be similar, which you have identified in the what you are actually implementing. So your de-identification techniques used should be in line with the results of your privacy impact assessment. Next. So de-identification and deletion at the end of processing. When not needed for processing, PII should be deleted or de-identified. And then retention, keep PII for the shortest period possible to serve the purpose. PII transmission control should be there, secure PII transmitted and ensure that it reaches the destination. And you also need to delete the temporary files as soon as they are not needed for the processing. And you need to choose a adequate mechanism for disposal. So 7.5 is PII sharing, transfer, and disclosure. Identity basis for PII transfers between jurisdictions. So you have to comply to the applicable legislation. For example, data transfer outside the EU is under the GDPR. So adequacy decisions have to be taken. Safeguards are required. For example, standard contractual clauses, binding corporate rules, certification mechanisms, PIA principle information and consent. So PI sharing, transfer and disclosure, countries and international organizations to which PII can be transferred. So document and make available to customers. The countries and international organizations to which this PII can be transferred. Record of transfer of PII, you have to maintain the record. Keep record of PII transfer and cooperate with the third parties. And record of PII disclosure to third parties. Maintain record of PII disclosure to the third parties and maintain a record. So you can have a small exercise.
All right, sir. Sagar, please share the barcode on the screen. Thank you. As well as the link in the chat box. So I request all participants to kindly actively participate and submit their responses for this workshop. So we will wait for a few responses to come and then we will initiate with the stats for the responses. Sagar, please let me know once we have received the few responses. And I request participants who have submitted the responses kindly mention in the chat box. Mr. Lakshmi Narayan Sharma ji submitted. Great Lakshmi ji, congratulations. Mr. Faizan Malik already submitted. Congratulations, Mr. Faizan Malik. Sneha ji submitted. Congratulations, Sneha ji. Awaiting for more responses and submitting their names. Mr. Rahul Sharma submitted. Congratulations, Mr. Rahul Sharma. Mr. Yatish Kumar submitted. Congratulations, Mr. Yatish. Swati Kulkarni ji submitted. Congratulations, Swati ji. All right. So now here we are going for the stats. The first question, what is the key responsibility of PII controllers under the clause 7.2? And the correct answer for this question, ensuring lawful and fair collection and processing of PII. And for this question, we have received 100% answer are the correct answers. So again, congratulations to all for submitting the correct answer. Next, please. Question number 2. Clause 7.3 requires that PII controllers must inform data principals about. And the right answer is the identity of the controller and propose the data processing. And also for this question, we have received 100% answers are correct ones. Again, congratulations to all. Moving to question number 3. What does clause 7.4 focus on the context of privacy? And the right answer is privacy by design and privacy by default. And again, for this question, we have received 100% answers correct ones. Again, congratulations to all. Next, please. Fourth question. Which of the following is required when sharing or disclosing PII as per clause 7.5? And right answer, explicit consent and documented legal basis. And again, for this question, we have received 100% answer are the correct answers. Again, kudos to all who have submitted correct answer. Move on to next, please. Fifth question for this workshop, clause 7.1 general reaffirms that PII controller must. And the right answer is define the scope of processing in a transparent and accountable manner. And for this question, we have received 92% answers are the correct answers. So by seeing the responses for this workshop, I am overwhelmed, and thank you again for all participants for actively participating and submitting their maximum responses. Thank you. I request Atul Suri sir to resume this training session. Thank you.
Okay. Before moving to clause 8, I will just explain you a methodology for data protection impact assessment based on GDPR guidelines. So how to conduct a data protection impact assessment? So a data protection impact assessment is required under the GDPR. Anytime you begin a new project that is likely to involve a high risk to other people's personal information. So it is mandatory wherever a high risk category is there with respect to other people's personal information. So the European Union's General Data Protection Regulation includes several rules which organizations have to follow in order to protect the personal information which they collect about their clients or people who visit their websites. So organizations which fail to comply
comply GDPR, and this GDPR has become applicable in the month of in the year 2020. So I'll just tell you about the exact date since when it is applicable. So this came into application from 25th May 2018, GDPR. So organizations which fail to comply with the GDPR are risking severe penalties, which includes fines up to $20 million or 4% of their annual revenue, whichever is higher. So the Article 35 of GDPR covers data protection impact assessment. And this is a requirement which the organizations have to follow as part of protection by design principle. So according to this law, where a type of processing in particular using new technologies and taking into account the nature, scope, context and purposes of the processing is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall, prior to processing, carry out an assessment of the impact of the envisaged processing operations on the protection of personal data. So it is very clear as per Article 35 that it is a requirement as part of protection by design, and wherever you are using some new technologies and taking into account the nature, scope, context and purpose of processing, which is likely to result in high risk to the rights and freedoms of natural persons. So controller has to mandatorily carry out an assessment of the impact of the envisaged processing operations on the protection of personal data. So where it is mandatory, examples are if you are using some new technologies or if you are tracking people's location or their behavior, or if you are systematically monitoring a publicly accessible place on a large scale, or if you are processing personal data related to racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union membership, and processing of genetic data, biometric data for the purpose of uniquely identifying a natural person, data concerning health, or data concerning a natural person's different orientations. So if your data processing is used to make automated decisions about the people, that could have legal or similarly significant effects, or if you are processing children's data, or also if the data which you are processing could result in physical harm to the data subjects if it is leaked. So basically, in that case, you have to mandatorily do a risk assessment, that is a data privacy, data protection impact assessment. And there are certain other obligations also. I will just tell you what these are. So when we talk about lawful business and transparency, so organizations which employ at least 250 employees or conduct higher risk data processing are required to keep an up-to-date and detailed list of their processing activities and be prepared to show that list to the regulators whenever they ask for it. So basically what you need to do is they need to do a data protection impact assessment, and organizations which have lesser employees, that means less than 250 employees, they are also advised to conduct an assessment because that will help them in compliance to GDPR requirements in a better way. So what should be included in the list? It talks about the list of processing activities. So it should include the purpose of processing, what kind of data is being processed, who has the access to that data in the organization, any third parties which are involved and where they are located and which are having the access to what you are doing to protect the data, for example, the encryption, and when you plan to erase it wherever possible or if possible. And processing of data is illegal under the GDPR unless you can justify it according to one of the 6 conditions which are listed in Article 6. So Article 6 has a list of this thing. So you have to justify it according to one of those 6 conditions. And there are also provisions related to children and special categories of personal data, which is mentioned in Article 7 to 11. So you need to review these provisions and also choose a lawful basis for processing and document your rationale. So basically, without meeting one of these requirements which are mentioned in Article 6 and Article 7 to 11, if you are dealing with children or special categories of personal data, so you have to justify the rationale for processing of the data. Otherwise, it is considered illegal. So note that if you choose consent as your lawful basis, then there are extra obligations, including giving data subjects the ongoing opportunity to revoke the consent. So if legitimate interest is your lawful basis, you must be able to demonstrate that you have conducted a privacy impact assessment. So if you are employing 250 people or more and conducting high risk data processing, then this data protection impact assessment is mandatory, and you need to maintain a detailed list of the processing activities. And then you also had, even if you're employing lesser employees, then still better to do a proper data protection risk assessment, impact assessment, because that will help you in better compliance to the requirements of GDPR. And then processing of data is considered illegal unless you meet one of the requirements which are mentioned, one of the six conditions which are mentioned in Article 6. And there are certain other conditions if you are processing data related to children and special categories of personal data. So Article 7 to 11. And then once you take it, yes, it is there, then there are extra obligations also which you need to meet. And Article 12 says you need to tell people that you are collecting their data and why. So you should explain how the data is processed, who has the access to this data, and how you are keeping it safely. So this information should be included in your privacy policy and provided to data subjects at the time when you collect this data. And this information has to be presented in a concise, transparent, intelligible, and easily accessed form using clear and plain language, and in particular for any information which is addressed specifically to a child. So one thing is the applicability, that is lawful basis and transparency. The next requirement is data security. So the organizations have to follow the principles of data protection by design and by default, including implementing appropriate technical and organizational measures to protect this data. And in other words, the data protection is something you now have to consider whenever you do anything with other people's personal data. So you also need to make sure that any processing of personal data adheres to the data protection principles which are outlined in Article 5 of GDPR. And these technical measures include encryption and organizational measures like limiting the amount of personal data you collect or deleting the data you don't require anymore. The point is that it needs to be something you and your employees are always aware of. So awareness of employees is also very important. Otherwise, it may lead to some breach or some non-fulfilling the requirement of GDPR. So it says that even if your technical security is strong, your operational security can still be a weak link. So you have to create a security policy which ensures that your team members are knowledgeable about data security. So it should include guidance about email security, password, two-factor authentication, device encryption, and VPNs. And the employees who have access to personal data and non-technical employees should receive extra training in requirements of GDPR. So adequate awareness and training on the requirements of GDPR is a must.
Sorry to
So,
disturb you, sir, but
yeah.
on which slide we are and what is being presented?
This is not there in slide. I'm again repeating you. There are certain things which are not there in slide, but I'm still explaining for means better clarity.
Okay. Understood.
Yeah. So I have not started clause number 8. Basically, I'm just trying to explain the importance of data protection impact assessment and how it can be related to, because see, GDPR is mandatory since 25th May 2018, but in our country, your DPDP Act still rules are being framed, and so it may take some time. So
Yes,
I'm just explaining the importance and how this data protection impact assessment is required as per GDPR.
Perfect. Perfect. Thank you.
And yeah, so all this is not there in slide, but this additional information again as a PDF document can be shared with all the participants. So I will share this information with Sagar and Praveen, and when they are mailing this information, this PPT, so this additional information, just for better understanding also, they will share with you. So this is not part of slides. So the regulation also says that if there is a data breach and personal data is exposed, then you are required to notify the supervisory authority in your jurisdiction within 72 hours. So Notifying the supervisory authorities in the jurisdiction within 72 hours in case there is a data breach and personal data is exposed is also a requirement. So you are required to quickly communicate data breaches to your data subjects unless the breach is unlikely to put them at risk. For example, if the stolen data is encrypted. Then the next requirement relates to accountability and governance. Another part of data protection by design and by default is making sure someone in your organization is accountable for GDPR compliance. So this person should be empowered to evaluate data protection policies and implementation of those policies. And this also includes any third-party services which handle the personal data of your data subjects, including the analytics software, email services, cloud server, etc. And if you process data related to people in one particular member state, so you need to appoint a representative in that country who can communicate on your behalf with data protection authorities. So GDPR and its official supporting documents do not provide guidance for situations where processing affects EU individuals across multiple member states. So until this requirement is interpreted, it may be prudent to designate a representative in a member state that uses your language, because EU also has got certain different languages. So they are saying that if you are processing data related to people in one particular member state, then you need to have a local representative who can communicate on your behalf with the data protection authorities. Otherwise, language could be a barrier. Some organizations like public bodies are not required to appoint a representative in the EU. And there are 3 circumstances in which organizations are required to have a data protection officer. And this DPO should be, that is data protection officer, should be an expert on data protection whose job is to monitor GDPR compliance, assess data protection risk, advise on data protection impact assessment, and cooperate with the regulators. The next requirement relates to privacy rights. So people have the right to see what personal data you have about them and how you are using it. So they also have a right to know how long you plan to store this information and the reason for keeping it at that length of time. So you have to send them first the copy of this information for free, but later on you can charge a reasonable fee for the subsequent copies. So make sure that you can verify the identity of the person requesting the data, and you should be able to comply with such requests within a month time. So there is Article 15 and Article 16 also, so which says do your best to keep data up to date by putting a data quality process in place and make it easy for your customers to view and update their personal information for accuracy and completeness. Make sure you can verify the identity of person requesting the data, and you have to comply with the request under Article 16 within a month. And it also talks about the right to delete the data. People generally have the right to ask you to delete all the personal data you have about them, and you have to honor their request within a month. So if the people ask you for deleting their personal data, so you have to honor it within a month. So there are 5 grounds on which you can deny the request, such as the exercise of freedom of speech or compliance with a legal obligation. And you also need to verify the identity of person who is making the request. And your data subjects can also request to restrict or stop processing of their data if certain grounds apply. Mainly if there is some dispute about the lawfulness of the processing or the accuracy of the data. And again, you are required to honor their request within about a month's time. So while the processing is restricted, you are still allowed to keep storing their data. And again, you must notify the data subject before you begin processing their data again.
So one query.
Yeah.
So where are you referring these articles? In which document?
See, this article is not there in the slide. So as I explained, there is a separate document, and you will get this document which I'm explaining right now along with the PPT. So basically, it talks in detail about how data protection, risk assessment, impact assessment is to be done as per GDPR requirements. What are the specific requirements of GDPR, and how the organizations have to ensure that. So there is a separate document. It is not part of this PPT, but you will get it as an annexure.
Okay. So is it a guideline separately?
It is a guideline on how to implement GDPR requirements and how to carry out risk assessment based on GDPR requirements.
Okay, GDPR. ठीक है sir. Thank you.
Yeah, you will get it separately in
जी,
addition.
जी.
So I just thought of it during the lunch break so that I can explain this process in a better way. So it was not in the original slides, but definitely it will be shared with all of you.
All right. Thank you.
And the last thing which it mentions is sometimes organizations use automated processes to help them make decisions about the people that have legal or similarly significant effects. If you think that applies to you, you will need to set up a procedure to ensure you're protecting their rights, freedoms, and legitimate interests. You need to make it easy for people to request human intervention to weigh in on the decisions and challenge decisions you have already made. So basically, this document is titled as GDPR checklist and how to conduct a data protection impact assessment. So that will be mailed to you along with this PPT. Okay. So now we move to clause number 8. Clause number 8 is additional guidance for PIE processors. So there are 5 subclauses. 8.1 is general. 8.2 is about conditions for collection and processing. 8.3 is about obligation to PI principals. 8.4 is privacy by design and privacy by default. And 8.5 is PI sharing, transfer, and disclosure. Okay. So move on to the next slide, please. So 8.1 is general. 8.2 is conditions for collection and processing. So basically we have a customer agreement, organization's purpose, marketing, and advertising use. So customer agreement, the contract with the customer should specify the role of the organization in providing the assistance. Organizational purpose, PI processing only for purposes specified by the customer and according to its instructions. Marketing and advertising use, do not use PI for marketing and advertising in the absence of PI principal concept. So the objective is to determine and document that processing is lawful with legal basis as per applicable justification and with clearly defined and legitimate purpose. So for that, we have a customer agreement. So organization should ensure that wherever relevant, the contract to process PIA addresses the organization's role in providing assistance with the customer's obligations, that is, taking into account the nature of processing and information available to the organization. And the contract between organization and the customer should include, wherever relevant, the following things like, and depending on customer's role also, whether PIA controller or PI processor. For example, privacy by design and privacy by default. Then achieving the security of processing, notification of the breaches which involve PI to a supervisory authority, notification of breaches involving PI to customers and PI principals, conducting privacy impact assessment, and the assurance of assistance by the PI processor if prior consultation with relevant PI protection authorities are required. And you also need to discuss the organizational purposes, organization's purpose, that is PI processing only for the purpose specified by the customer and according to its instructions. So in order to achieve this thing, there can be technical reasons why it is appropriate for the organization to determine the method for processing PIA consistent with the general instructions of the customer, but without customer's express instructions. For example, in order to efficiently utilize network or processing capacity, it can be necessary to allocate special processing resources depending on certain characteristics of PI principle. So what the organization should do is it should allow the customer to verify their compliance with the purpose specification and limitation principles. And this also ensures that no PIA is processed by the organization or any of its subcontractors for other purposes than those expressed in the documented instructions of the customers. And for marketing and advertising use, organization should not use PIA processed under a contract for the purpose of marketing and advertising without establishing that prior consent was obtained from the appropriate PI principle. Then conditions for collecting and processing infringing instruction. Inform the customer about processing instruction that could be infringing the legislation. Customer obligations, provide the necessary information required for meeting the obligations. And records related to PI processing keep records to demonstrate that obligations are fulfilled. Then obligation to PIE principals. Objective is to ensure that PIE principals receive appropriate information about the processing and that any other obligations towards them are met. So support the customer in meeting his obligations to PIE principals. Privacy by design and privacy by default. So temporary files, delete, destroy or otherwise dispose of temporary files as soon as they are not needed for the processing. Then PII transmission controls, secure PII transmitted according to the contract or the instructions of customer. And return, transfer or disposal of PII. Document and make available to customers a policy on retention and disposal of PII at the end of processing. So the objective is to ensure that processes and systems are designed such that collection and processing of PIIs, which includes use, disclosure, retention, transmission, and disposal, are limited to what is needed for the identified purpose only. So what you need to do is ensure that temporary files created as a result of processing of PII are disposed, that is, they are erased or destroyed, following the documented procedures within a specified documented period. And for that, you also need to conduct periodic verification that unused temporary files are deleted within the identified period. Then return, transfer or dispose of PIA. So you need to provide the ability to return, transfer and dispose of PIA in a secure manner, and it should also make such policy available to the customer. So the last clause is PIA sharing, transfer and disclosure. So transfers, basis for PIA transfers between jurisdictions, inform the customer on the basis for transferring PIA to other jurisdictions so that customer can object. Countries and international organizations document and communicate to the customers the countries and international organizations where PII can be transferred during normal operation. Records of PII disclosures. So record all PII disclosures, what, to, whom, and when. And notification of disclosure request, that is inform the customer on PII disclosure requests. And also legally binding PII disclosures, reject any PII disclosure request that is not legally binding and consult with the customer. And disclosure of subcontractors used to process PII, inform the customer on subcontractors and countries where the PII can be transferred. Engagement of a subcontractor to process PII, so obtain an authorization from customer before subcontracting PII processing. Change of subcontractor to process PII, obtain the authorization from the customer for changing subcontractors. So I'll explain a little bit more. So PII sharing, transfer and disclosure. The objective is to determine whether and document when PII is shared, transferred to other jurisdictions or third parties and or disclosed in accordance with the applicable obligations. So the organization should inform the customer in a timely manner of the basis for PII transfers between the jurisdiction and of any intended changes in this regard, so that customer has the ability to object to such changes or to terminate the contract. So PII transfer between jurisdictions can be subject to the legislation and regulation depending on the jurisdiction or the organization to which the PII is to be transferred or from where it originates. So what the organization should do is it should inform the customer of any transfer of PII, including transfers to the suppliers or other parties or other countries or international organizations. And in case of any changes, organization should inform the customer in advance according to the agreed time frame so that the customer has the ability to object to such changes or to terminate the contract. So you have to keep the customer in the loop. And the agreement between organization and customer can have certain clauses where organization can implement the changes without the information to the customer. But in these cases, the limit of his allowance should be set. For example, the organization can change suppliers without informing the customer, but cannot transfer the PII to other countries. So maybe within your own country, you can transfer to other, you can change supplier, but you cannot transfer that information to outside the countries. So you need to refer to some model contract clauses, binding corporate rules, or cross-border privacy rules, etc., the countries involved, and the circumstances in which such agreements imply. So these have to be properly identified. So next, you can have a small exercise.
Yes, sir. All right, sir. Sagar, please share the barcode on the screen. Thank you. And as well the link in the chat box so that the participants can get access to the workshop. And all participants kindly get access of this workshop and submit your responses. We are waiting for your responses to come. Then initiate the stats for the workshop. Participant, those who have submitted their responses, kindly mention on the chat box. Mr. Devdeep Ghosh submitted. Congratulations, Mr. Devdeep ji. Sneha ji submitted. Congratulations, Sneha ji. Alvin submitted. Congratulations, Alvin ji. Swati ji submitted. Congratulations, Swati ji. Yatish Kumar ji submitted. Congratulations, Mr. Yatish. We're waiting for more responses. So now we are going with the stats. First question, under clause 8.2 general, PII processor must act. And the correct answer for this question, only within contractual and documented instruction from the PII controller. And for this question, we have received 91% answers are correct answers. Congratulations to all who have submitted their responses correctly. Next, please. Second question, clause 8.2 states that PII processor must ensure that, and right answer is conditions for processing are defined and agreed with the controller. And for this question, 100% answers are the right answers. Again, congratulations to all. Move on to next, please. Sorry, it is, yeah, now we are moving on to third question. Yes. Question number 3, what does clause 8.3 requires PII processor to do in relation to PII principles? And answer is fulfill the controller's obligations to PII principles if requested. And 93% answers are the correct answers. Again, congratulations to all. Next, please. Fourth question, clause 8.4 requires PII processors to apply. And the right answer is privacy by design, privacy by default in coordination with controller. And for this question, we have received 93% answers are the correct answers. Again, congratulations and kudos to all for submitting the responses correctly. Next, please. Fifth and last question, which of the following is a requirement under clause 8.5? And the answer is transfer of PII must comply with applicable contractual and legal obligations. And for this question, we have received 81% answer are the correct answers. So again, I appreciate your activeness and submitting in responses for the workshop. And again, congratulations to all. Moving on to next. Atul Suri, I request Atul Suri sir to resume the training session.
Certification to ISO IC 27701. So this ISO IC 27701 is a certifiable extension to ISO 27001 for establishing a privacy information management system. So who can get certified? So organizations which are already certified to ISO 27001 and process PII as controllers, processors or both, and those who have implemented additional PMS controls for ISO IEC 27701. So certification is typically issued by an accredited certification body after successful PMS audit building upon ISO IEC 27001. So that means you are already certified to 27001 and then you have implemented the additional PMS controls from 27701 and after successful PMS audit you can be certified to ISO IEC 27701. Next. So now we come to the part of, because one of the requirements was internal auditing also. So now we come to the internal auditing part. So what is internal audit or what kind of audits are there and how this internal audit is conducted? What are the requirements? So all this we will discuss in the subsequent slides. So audits, definition, principles and types. So what is an audit? So basically these slides, those who have attended the previous sessions also, these are the identical slides related to auditing methodology, auditing process. So audit, definition of audit is systematic, independent and documented process for obtaining the evidence related to auditing and evaluating it objectively to determine the extent to which the audit criteria is fulfilled. So audit is a systematic activity, it is an independent activity, and it is also a documented process for obtaining the evidences and evaluating them with respect to a norm, evaluating them objectively to determine the extent to which criteria for auditing is fulfilled. So alternative definitions can be impartial documented activity, which follows written checklist or documentation and uses examination of audit evidence to determine the existence of objective evidence and verifies that applicable processes of the management system, whatever you are implementing, have been identified and are effectively controlled. So important thing to understand is that audit is a systematic, independent and documented process for obtaining the evidence and evaluating that evidence objectively to determine to what extent the criteria against which we are auditing is fulfilled. Next, so why we are conducting audit? Basically, we are examining the effectiveness of privacy information management system for the improvements and compliance to the requirements of standard ISO 27701 to ensure ISO 27701 and all other standards against which we are auditing, they are complying with, to determine the compliances or non-compliances, to meet regulatory requirements, and it is also a certification requirement that before certification, before award of certificate, you need to have completed internal audit and close the findings with respect to the non-compliances or any areas for improvement. So reason for conducting audit is examining the effectiveness of your PIMS, ensuring that it meets the requirement of standard or all other standards against which you are auditing, and determining compliances or non-compliances, if any, to meet and address the regulatory requirements, and also as a part of the requirement of certification to enable a certification. Next, so we are conducting effective audits. What are the requirements? The requirement includes timely access to facilities, documents, and personnel, including the availability and interaction with the top management. So you need to have defined auditing methodology or procedures, and you also require the support and involvement of management or the local management. And most importantly, you require a competent audit team, the audit team members who understand the requirements of the standards and who basically can meet those requirements. So you require a competent audit team, and this audit has to be conducted impartially by the audit team. Next, so normally three types of audits are there: first party audit, second party audit, and third party audit. Next, so when you are conducting audit within the organization, that is known as internal audit or the first party audit. So this audit is performed within the organization and the auditors have no vested interest in the area being audited. So one thing you need to take care is that auditors cannot audit their own work. So auditors should not be basically linked with that particular process for which they are conducting the audit. So auditors have no vested interest in the area being audited. Next, second party audit, when you are auditing your supplier or your customer audits your organization, so that is a second party audit. So second party audit is performed by customers on the suppliers, and this can be done before or after awarding a contract. So that is known as second party audit. Customer auditing the organization or the organization auditing its supplier. So that is a second party audit. Next, third party audit, when an independent organization which is not at all linked with your business processes audits you. For example, Quality Asia auditing your organization. So that is known as a third party audit. So this audit is performed by an audit organization independent of the customer supplier relationship, and of course there is no conflict of interest involved. So that is known as third party audit performed by an audit organization which is independent of customer supplier relationship. Then who are the audit participants? So client, auditor, and auditee. So client is the organization or the person requesting the audit is an audit participant. The auditor, a person with the desired competence to conduct the audit and who conducts the audit, is an auditor. And the organization or the individual being audited is known as the auditee. So client, auditor, and auditee are involved in the audit process. Next, so there are certain roles and responsibilities. The client is responsible for initiating the audit. For example, your organization decides to get certified to ISO 27701. So you initiate the audit, you basically approach the certification body for the auditing purpose for the award of certificate, and auditing methodology is there where your stage 1 audit is conducted, stage 2 audit is conducted. If any non-conformances are there, those non-conformances are closed, and then finally you get a certificate. But client is the one who is initiating the audit by approaching the certification body for initiating the audit process. Then certification body determines the audit purpose and scope, because scope is basically informed by the client to the certification body, and certification body verifies that scope and conducts the audit as per that scope. But it is a client responsibility to determine the audit purpose and inform the scope to the certification body. And when the actual audit happens, the client is responsible for providing the desired resources for smooth conduct of the audit. And on conclusion of the audit, the client receives the audit report, and to whosoever he feels fit, that report is distributed within the organization or sometimes shared with the customers also. And any actions which are required based on the audit report, suppose some non-conformances are there, so these have to be closed. So all those actions are taken by the client. Next, so auditor is responsible for conducting the audit. So understand the purpose, scope, and conduct of the audit criteria. So audit is plans the audit. Auditor or the team of auditors or the lead auditor conduct the audit, perform the audit. They collect audit evidences, they analyze the audit evidences and report the audit. Finally, prepare a report and follow up on whatever actions are there which are found during the course of the audit. So that is audit findings. And lead auditor is the team leader who is responsible for, because sometimes audit team has got different team members. There's a team audit team. So the lead auditor is the team leader. So he or she balances the strength and weaknesses of the team members, manages the audit process. He's also representing the audit team because he's also part of the audit team. So he's doing audit also. He basically leads the audit team, and finally the preparation and completion of audit report is done by the lead auditor. Next, and the auditee whose audit is being done, or the department head whose audit is being done. So he informs the staff. He provides the resources which are required for conduct of audit, for example, interview room, communication, and what kind of other support is required. Sometimes, because the third-party auditors, they are visiting the organization first time, so they don't know about the various processes where these are being conducted. So sometimes, as per requirement, he assigns a guide also for the auditing. Audit is responsible for showing the objective evidence of what the auditor is asking for, and he's also supposed to cooperate with the audit team. And in case any non-conformities are identified, so audit is responsible for determining and initiating those corrective actions. So the responsibilities of auditee we had already discussed. Move on to next slide. So technical experts. So sometimes especially in case of third-party audits, technical expert also accompanies the audit team. Technical expert is a person who provides specific knowledge or expertise to the audit team. So it's more like an advisor to the auditors or the team of auditors, and basically it is a requirement of accreditation. So sometimes technical expert, that is a person who provides specific knowledge or expertise to the audit team, is also a part of audit team. Then there can be an observer, a person who accompanies the audit team but does not audit. He is like a trainee auditor. So for becoming an certification body auditor, the qualified lead auditor means those who have done the lead auditor course for the respective standard, and they need to be observers for certain number of audits as per the procedure of certification body to be an observer. So during that observer phase, the concerned person accompanies the audit team, observes the audit for learning purpose, but does not participate in the audit. So sometimes observers are also there, and guide is normally a person appointed by the auditee to assist the audit team in bigger organizations, because audit team, when they are visiting first time or second time, they are not aware of the various sections or the processes of the organization or departments of the organization. So guide is a person who takes them to various sections. So Sometimes audit team also includes technical expert, observer, or guide. Next. So there are different phases of audit, just like PDCA, plan, do, check, and act. So there is planning phase, preparation phase, performance phase, reporting, and follow-up phase. Follow-up phase for the audit. So when you're doing the planning is more about frequency and timing for the audit. Who is responsible? That is the responsibility, the criteria, the scope, the methods, and duration. Next. So when we talk about planning internal audits or even third-party audits or even second-party audits, planning is frequency and timing based on the status and importance. So normally the key activities during the planning phase of an audit, while making an audit plan, key activities are given more time for audit and support functions are given lesser time. So that is basically the responsibility of the lead auditor, or if it is an internal audit, this is the responsibility of the representative, management representative, or data protection officer in case of ISO 27701. And who is responsible for conducting audit? Competent audit with the desired technical knowledge. And what criteria we use for auditing? The organization's own procedures, specifications, documents, the external standards, for example, ISO 27701, 2019, or whatever management system against which we are doing the audit. The scope can be a process, an area of the organization, or the complete organization. And how much to audit, the duration of audit depends on the size of the scope. So there are certain guidelines if you are a certification body auditor or if you are a certification body. So there are certain guidelines as per the accreditation board requirements or other international standards which they have to follow, based on which they define the frequency, the timing, the audit mandates, the audit team composition, etc. Next. So when you are conducting a second party audit, that is when you are auditing your own suppliers, the frequency and timing is determined by the organization. So again, you require a competent auditor with the desired technical knowledge, and contract criteria is contractual obligations, organization's management system, regulatory requirements, or the requirements which are defined in ISO 27701 or the agreed standard against which you are doing the audit of your supplier. Again, the whole facility can be audited or a particular area of the organization. For example, IT processes or ISMS process functions or PIA functions processing activity can be audited. So it depends. Basically, it is mutually decided, agreed. So it can be entire facility or a particular area of the organization. And audit duration also is mutually decided. Next. And when you are planning for the third-party audits are done by certification bodies like Quality Asia. So they have their own procedures based on the requirements of accreditation board. So here also frequency and timing is required, but that is determined as per the accreditation requirement ISO 17021 or sector specific standard. And the responsibility for executing audit is of qualified auditor with technical knowledge and experience. So for that, certification bodies have their own procedures and norms for auditor qualification. The criteria can be ISO 27701 or any other standard against which the audit is being conducted. And again, the scope can be the entire organization or management system operations, which are covered under the applicable standard, that is ISO 27701 in this particular case. And the duration of audit, that is audit mandates, again, there are guiding principles, formulas, and guidelines based on the accreditation requirement to which certification body follows. So frequency and timing, responsibility, criteria, scope, and duration is there in case of all three audits: first party audit, second party audit, third party audits. But requirements and the basic details vary from audit to audit. Next. Audit procedure. External audits are usually agreed in advance with the auditee and carefully planned. However, sometimes unannounced audits may also be carried by the certification body or customers and their representatives as a policy, or when there is some justification for doing such an audit. Otherwise, in general, auditing is a planned activity. So whether it is internal audit, first party audit, second party audit, third party audit, these are basically planned in advance and agreed with the respective auditees, and a proper audit plan or schedule is prepared. So activities which are done prior to conduct of audit, in audit program, audit plan is prepared, and the same is informed to the client or the auditee. Then external audits like second party audit or third party audit require audit logistics also, so they have to be arranged. And sometimes auditors prepare their own checklist, or in case of supplier audit, the organization prepares a checklist for the suppliers to be followed. So it depends. Although checklist is not mandatory, but then it can serve some useful purpose also. So sometimes audit checklists are also part of that audit execution. Next, audit preparation. So when audit preparation is done, you notify the person to be audited and agree to a date and time. You prepare as an auditor, prepare and review and update your checklist. So you review the documents, procedures, formats, previous reports, corrective action requests, work instructions, SOPs, manuals, plans, etc. And you brief the auditor or audit team. So these are all part of audit preparation. Next. So in case of second party audit or third party audit logistics may also be involved, which includes travel and accommodation, then safety, security considerations, shop floor, if shop floor visit is required, PPs or some location, camera permit, need for a guide, translators, facilities. So as required, these audit logistics are to be taken care. Facilities, working area, conference room, internet, printer, etc., etc., as per the requirements. So these are a part of audit logistics. Next. So sometimes audit checklists are part of the audit execution. Though checklists are not mandatory, but different certification bodies have different procedures. So according to that, some certification bodies have audit checklists also. Sometimes audit checklists exist in case of second party audit also, because you want your suppliers to fulfill the requirements of a particular standard or a number of standards. So that way audit checklists can be prepared. Sometimes these checklists basically help the auditors also. Basically, it provides guidance to auditors so that nothing is left out. But it depends upon the experience of the auditor, and normally very experienced auditors, they rarely use checklists because by virtue of their experience and knowledge, they know what they need to check and verify. But for beginners and for lesser experienced auditors, it is always better to have a checklist so that they don't miss out on anything. So checklist to be used as a working document and as a record, and it can be a tool to audit a company processes, not standard, and should follow the natural process of the organization. The purpose of checklist is to provide guidance to the auditor to ensure that audit scope is covered, that is various processes, activities, and to reinforce the objectives and scope of the audit. And the filled checklist also acts as a record. But the risk of checklist is then you become too focused on a single area. Sometimes the checklist itself is inadequate, so insufficient information included to evaluate conformance in interviews, and sometimes it is not customized to reflect company's practices. So both advantages and disadvantages of using the checklist are there. Audit checklist can be prepared as per the requirement of the standard, or as per, let us say, if you want to audit your suppliers, then depending upon what exactly you are looking for in suppliers processes, that checklist can be prepared. So any kind of checklist which fulfills the requirement is okay. Next. So when the audit is actually conducted, basically an opening meeting is conducted, followed by conduct of audit, followed by review of findings, and finally the closing meeting. So audit performance includes opening meeting, conduct of audit, review of findings, and finally a closing meeting. Next. So normally an opening meeting is conducted, especially in case of second party audit, third party audits. But it should also be done in internal audit. Sometimes internal audit, a formal opening meeting is not done, but it is always advisable to have an opening meeting in case of internal audits also. The objective is because in internal audit, the auditors and auditees know each other. But in second party and third party audits, it is required because auditors and auditees don't know each other in most of the cases. So it is always better to have an opening meeting, and it is a requirement of the, for third party audits, it is a mandatory requirement also to have a opening meeting and closing meeting. So the objective of opening meeting is to introduce auditors and audit team, and in case of third party audit, the certification body has its own agenda for the opening meeting, and all those points have to be discussed in the opening meeting. So introduction of auditors and audit team is done in the opening meeting, where they discuss and inform about the audit process, audit scope. They explain the reporting process, follow-up procedures, and this opening meeting is required for good communication, proper conduct of audit, cooperation from the auditee side, and proper openness. Next. So when you are an auditor, so you must deal with the top management. You should be able to understand what are the key processes in the organization, what are the focus areas or the critical activities. And this audit is done for process improvement, business improvement, and ensuring compliance with the legal requirements as applicable for the particular standard or number of standards. So what you need to do is you meet the area representative. You should also always talk to those who are performing the task. Explain the purpose of your visit. You have to be calm, polite, reassuring. As an auditor, you must never act superior and never talk down, and you must also speak clearly and carefully. These are the basic requirements for auditors. Next. So the audit process is about gathering audit evidence. So you have a source of information, you get information from that, you verify it from the audit perspective, that is audit evidence. You conclude on the audit findings, you verify it compared with the audit criteria, and finally you make audit conclusions. So source of information, gathering and selecting by document review, interviewing, observing, etc. Then verification of information, comparison with the audit criteria, finally audit findings, the review, and the outcome is audit conclusion. Next. So there are different ways and means by which audit evidence can be collected by the auditor. So it may be gathered from interviews with people, observation of activities, how different functions, activities and processes are interacting with each other, measurement of processes, programs, documents, records, data summaries, reports from other sources. So there are different ways from which you can collect the what are the applicable requirements, how those requirements are being met. Then sector specific, standard specific requirements, like for example here in case uh, how that data protection impact assessment study has been carried out, what are the findings. So you have to correlate with the requirements of the particular standard for which you are doing the audit. So you need to collect audit evidence, and you also talk to the people who are performing the task. You understand their level of awareness, because competence, training, awareness, these are requirements of all management system standards. So you need to interact with people, interview people to understand, to know how do they understand the systems and the documentation related to the particular standard against which you are auditing, or the audit scope or audit criteria. You need to assess whether these people are competent. Are they providing you the adequate cooperation, or there is cooperation between various team members of the organization, or are there any systematic problems, system problems? So all these are ways of obtaining audit evidence. Next. So continuing further, observation of activities. Are the processes efficient, effective? Are the things in logical sequence? Are the interaction between processes identified? What is the significance of links between these processes? Can inputs, outputs be identified? The measurement of programs, capacity of processes, product measurement, accuracy, dependability, cycle times, resource utilization, productivity. Now, specifically with respect to, since we are talking about ISO 27701, so we can look into your data protection impact assessment. So how this data protection impact assessment has been carried out, the nature of processing, how it is collected, used, stored, and data is deleted, what is the source of data, how this data is shared with anyone. So that means sector specific, standard specific, objective evidence you need to gather to reach to a conclusion. So what kind of objective evidence you need to collect or you need to verify depends on the particular requirements of the standard. Next, then document control is a requirement of every standard. So you need to assess the documentation also, their issue status, their completeness, accuracy, conditions, legibility, identity, approval, availability. Then data analysis, related data analysis, third party vendors assessment, customer feedback, internal audit, etc., etc. So what all objective evidence is required with respect to a particular requirement of the particular standard that you need to verify. You interview the employees, or you go through the records, or observe how the activities are being done. Next, you examine that objective evidence like documents, data, their accuracy, completeness, their authorization, review analysis of data. And again, these have to be standard specific. What all evidences you will verify. And objective is to establish the extent of conformity, or if it is violation of a particular requirement, then it is a non-conformity. So, and accordingly, what is the nature of non-conformity, you have to decide. And how many samples to take for objective evidence, that you have to decide as an auditor depending upon the time and the variety of evidence which is being given to you, which is being shown to you. Next, so sometimes you are using checklist also. So checklist can be used to record conformity or non-conformity. Then you need to do it proper time management also, especially as a second party auditor, third party auditor, even in internal audit also. But in internal audit, if you are not able to complete an activity in time, there's always a time next day also. But there is no such privilege in case of second party and third party audit, because time is limited, of course, as per the applicable mandates. So checklists can also help you to track where you are and manage your time to control the pace of the audit. And sometimes you need to manage auditee personalities also. Then you need to ensure that all areas as per the checklist are covered. Then checklists also help you to make notes for follow-up in other areas. And these checklists can be used for future reference also. So different type of questioning techniques are there: who, what, when, where, why, how. So basically such kind of questions are asked during interviews with the auditees. Who is responsible, what is being done, when it is done, where it is done, why it is done, how it is done. So these are certain basic questioning techniques which the auditors use, 5W and 1H. It is not like a why analysis. It is basically who, what, when, where, why, and how. Next. So an auditor, as an auditor or team member or lead auditor, you need to control the audit also, because there is a limited time for the audit as per the audit plan. And you need to ensure that people being questioned answer for themselves. Then as an auditor, you are asking question. So do as little talking as possible, because you have put up a question and auditee will explain. So answer is always lengthier than the question. So do as little talking as possible, and do not let others dictate the pace of the audit. Sometimes your questions could be misunderstood. So rephrase the misunderstood questions. Wherever you find some good work has been done by the auditee, so you can give good compliments also, give compliments also. Some basic courtesy, thank you, say thank you wherever required. And you also have to be aware of hidden agendas and emotional blackmail. Next, some basic rules you need to check and follow. Establish that company is demonstrating control over the processes or the operations. So you need to involve the management also in the audit process, because all management systems talk about leadership and commitment, and management has to provide the resources, and management has to ensure that all legal compliances, regulatory requirements are in place. So involve management also in the audit process. Observe work progression wherever required, whenever possible. Evaluate the evidences which you are collecting, which you are recording. Examine the process inputs, outputs, and also make comprehensive notes which will help you in preparing the audit report. Do not assume that people will lie, but seek to verify statements also if necessary, because you are auditing, you are interacting with different personnel, different teams. So sometimes you need to verify statements also. The information which you have collected in one department can be re-verified or can be verified in other department also, if you feel like verification is required. So seek verification wherever required. And important thing is do not accept pre-prepared samples. So sample, because auditing is a sampling exercise. So sample should always be selected by the auditor himself or herself and not by the one which is shown to you by the auditee. Next, so general principles of auditing which you need to follow always. Integrity, which is the foundation of professionalism. Fair presentation, that is obligation to report truthfully and accurately. Due professional care, that is application of diligence and judgment in auditing. Confidentiality, because you are getting privileged information or you are getting access to information which is provided to you by the auditee as a part of audit. So you have to ensure confidentiality or security of the information which is being provided to you as a part of audit. Then independence, the basis for the impartiality of the audit and objectivity of the audit conclusions. And most importantly, evidence-based approach, that rational method for reaching reliable and reproducible audit conclusions in a systematic audit process. So your approach should be systematic and evidence-based. Next slide. So there are auditor's personal attributes also. Auditor has to be ethical, that is fair, truthful, sincere, honest, and discreet. Auditor has to be open-minded, that is willing to consider alternative ideas or points of view. Auditor has to be diplomatic, that is tactful in dealing with people, because as an auditor, you deal with different personalities, different kind of people. So you have to be tactful in dealing with people. So as an auditor, you have to be observant, that is actively observing physical surroundings, activities, how the work is being performed. You have to be perceptive also, that is aware of and be able to understand situations. Versatile, that is able to readily adapt to different situations. Tenacious, that is persistent and focused on achieving the objective, that is the audit objective. And decisive, that is able to reach timely conclusions based on logical reasoning and analysis. And self-reliant, that is able to act and function independently while interacting effectively with others. So auditors' personal attributes are ethical, open-minded, diplomatic, observant, perceptive, versatile, tenacious, decisive, and self-reliant. Next. So general knowledge and skills of management system auditors. So you should be aware of audit principles, procedures, methods, management system and reference documents. You should be aware of organizational context, because all management system talks about understanding need and expectation of interested parties and internal and external context of the organization. So you should be able to understand the organizational context, and most importantly, applicable legal and contractual requirements and other requirements which apply to the auditee. You should be able to understand, you should have knowledge about the regulations, applicable regulations also, and how these regulations apply to that particular organization. And auditor should also have discipline and sector specific knowledge and skill of management systems. The senior most member of the audit team, or who is leading the audit team, is known as lead auditor. So generic knowledge and skills of audit team leaders. So audit team leaders should be able to balance the strength and weakness of individual audit team members, because ultimately lead auditor prepares the audit plan. So he or she must understand the strength and weaknesses of the individual team members and accordingly allocate them the auditing process, which to assess. So lead auditor must understand and balance the strength and weaknesses of individual team members. Then he or she should develop a harmonious working relationship among the audit team members, planning of audits and effectively using audit resources, managing the uncertainty of achieving audit objectives, protecting health and safety of audit team members wherever applicable, including compliance with the requirements, organizing and directing the audit team members. Then sometimes there are observers also, that is auditors in training, provide direction and guidance to auditors in training, prevent and resolve conflicts if they arise as necessary. The lead auditor is also representing the audit team and leading the audit team to reach the audit conclusions. And finally, the preparation and completion of audit report is done by the audit team leader. So these are the basic requirements for being a audit team leader. Next, so some good practices for auditors. They introduce themselves and the audit team members. They ensure that agenda is understood by the auditee. They stick to the agenda, keep control of audit and time, avoid arguments, listen to what is being explained by the auditee, maintain records, that is audit report, and remain polite, calm, and professional. Audit review. So before completing or before doing a closing meeting, the audit team members, they do a review amongst themselves. Sometimes because if audit is for several days, then interim or end of day review is also done if required with the auditees. So conduct a private review when the audit is finished. Interim or end of day reviews also may be appropriate. Review and complete checklist. Study and compare audit notes and list the non-conformities. So this is part of audit review. Next, analyzing the results. So review if the deficiency is an isolated error or a breakdown of the system. Review if the auditee is aware of the problem, and review if the deficiency has been reported before also. So if you find some deficiency or a non-compliance, so you review whether it is an isolated case or that deficiency is existing throughout the organization or the system, and whether the auditee is aware of this non-conformity or issue or not, or whether this deficiency has been reported earlier also. If reported earlier, what actions have been taken, root cause, correction, corrective actions, etc. Next, so on completion of audit, a closing meeting is held. So closing meeting is done in all the three cases: internal audit, second party audit, and third party audit also. So in the closing meeting, you explain the audit findings or discuss the findings, obtain an agreement, state overall degree of conformity or if non-conformity is there, and you also mention about the positive points. So in internal audits, the closing meeting is amongst the team members who are basically colleagues. So that is more informal, but it is constructive because internal audit is about verifying the effectiveness of the management system and identifying system improvement opportunities. So it is always constructive. Second party audit, closing meeting, if there are gaps, because if different organizations have different requirement for their suppliers. So sometimes contracts are also staked, sometimes based on the audit score. Let us say it is a checklist based and scoring based audit checklist. So they mandate ki minimum so much percentage, it can be 70, 80, 50, 60, whatever it is. So if the supplier scores lesser score, so even contract may be at stake, or contractor supplier may be blacklisted also. So it is more formal and it may also lead to sometimes contracts is also at stake. And these reports are always used as reference point. And these are more emotional situation as compared with the first party audit because business is also at stake. And third party audits also because these are related to certification decision. Because certification body allows the minor non-conformities subject to submission of root cause and corrective action. But major non-conformities lead to re-audit or non-recommendation of award of certificate, or let us say if the certificate was awarded earlier, then it may major non-conformities may lead to suspension of the existing certificate. So definitely here also certification is at stake, and these reports are always used as future reference because auditors always verify the previous reports, what kind of findings were there, and whether those findings have been effectively closed by doing a root cause analysis and correction, corrective actions, etc. So closing meeting is done in all the three cases, but yes, uh, output of closing meeting may be different depending upon the type of audit. Next. So when non-conformance is raised in the first party audit, that is internal audit, the objective is identification. Auditors identify non-conformities against the organization's internal procedures and specific ISO standards requirements. So these non-conformances are documented in the audit report. Root cause, correction, corrective action is done. Organization takes appropriate actions to address the root cause and prevent the reoccurrence. Verification is done through follow-up audit or reviews to ensure that the actions are implemented effectively. And the basic purpose of these non-conformances is to improve the internal system, ensure compliance, and have a better preparation for external audits. Next. So same when non-conformances are identified in second party audit, the basic purpose is that ensure supplier meets contractual obligations and the desired standards. The identification of non-conformity is done against the agreed terms, specifications, or whatever requirements against which the standard audit is done. And these issues are communicated to the supplier formally, and the supplier is required to provide a corrective action plan within the time frame. And the actions taken by the supplier include root cause analysis, correction, corrective actions, and preventive actions. And follow-up audit or supplier audits may also be done to verify the correction. So sometimes these verification activities are done off-site, and sometimes depending upon the findings, it can be done on-site also. So basic objective is that your supplier meets the contractual obligations and the desired standards. Next. So non-conformance in third-party audits, again, this is linked with certification process, regulatory compliance, or demonstrate conformance to standards. So normally certification body procedures say that non-conformities have to be classified as minor or major depending upon if it is an isolated case or it doesn't pose significant risk, then it is a minor non-conformity. But if it is a systematic failure or high risk non-compliance, then it is known as a major non-conformity. So these reports of non-conformities are included in the audit report, and these are communicated to the auditee. And auditee has to submit an action plan along with the root cause analysis, correction, corrective action, and a timeline is set to resolve the non-conformities. So depending upon certification body procedures, it is normally from 30 days to 90 days. And all major non-conformities require evidence submission and or re-audit depending upon the non-conformity. And minor non-conformities are checked during the next surveillance audit. So basically non-conformances management in third-party audit, it is linked with certification process, regulatory compliance, or demonstrating conformance to the respective standards. Next. So non-conformance statement is a statement which describes the non-conformity, which includes what, why, and the objective evidence. So what is the issue in question? That is the statement of non-conformity. Why this is a non-conformity? Because what the statement is used against. So that is the requirement or specific reference to the requirement is given for Y part. And then objective evidence, which was noted during the course of the audit, that is mentioned. The objective evidence observed, which supports the statement of non-conformity. Next. So when you're making a non-conformance report as an auditor, so this is used to report non-conformity, which is observed during the audit finding. Important thing is that this non-conformity report must be factual. It must be understandable and traceable to a particular requirement of the standard or organization's own documented procedures. And these non-compliances are raised on completion of the audit. And then you have to give time to allow the auditee to implement the corrective action prior to the closing meeting, or some cases these auditees submit the corrective action plan after the completion of audit, but non-conformance report has to be given to the auditor to the auditee so that they can take adequate actions on that. And audit is also requested to sign signifying an understanding and acceptance of the non-compliance. So the wording of non-conformance report is very important because it is important when preparing and wording non-conformance report to take care and ensure that it is justified, because failure to achieve clear information will invite challenge of the finding at the closing meeting. And this is particularly important in areas where the emphasis has changed with respect to the requirements in order that they will be clearly understood. That is management commitment, competence, communication, and continual improvement. So wording of non-conformity is important. So your non-conformity should factually report why it is a non-conformity, what is the supporting objective evidence, and what exactly is that non-conformity. Next, so this is an example of a non-conformance statement, a statement of non-conformity. The organization's employees lacked adequate awareness of Privacy Information Management System, PIMS, policies and procedures, leading to ineffective handling of PI-related risks and responsibilities. So why it is a non-conformity? Because the requirement of ISO 27701 2019 clause 7.3 for PI controllers oblique 8.3 for PI processors is persons working under the organization's control shall be aware of organization's PI protection policies, their roles in supporting compliance, and the implementation of not conforming to privacy management requirements. So they are not fulfilling this requirement. That is a non-conformity. And the objective evidence which was observed with support statement of non-conformity is during employee interviews, it was found that several team members handling personal data were unaware of PIMS policies or related data protection procedures, and no evidence or documented record of PIMS awareness training or communication was provided during the audit. So that is why it's a non-conformity. The statement is organization employees lacked awareness of those policies. This is against a particular clause of ISO standard, and the evidence is during the employee interview, several team members. Normally, we don't write the name of a team member. We just say team members because we should never write down the name of an individual like so and so. So during employee interview, it was found that several team members handling personal data were unaware of the policy or related data protection measures, and no training records were available. So audit reporting, audit reports should include auditors, contracts, scope, overall conclusion, deficiencies, observations, supporting objective evidence, follow-up details. So normally what is excluded from the report is any confidential information given in interviews or any matter which was not raised or discussed at the closing meeting, or subjective opinions, ambiguous statements, or antagonistic words or phrases. So these are not part of the audit report. Basically, audit report includes the details of auditors, contract, scope, overall conclusion, deficiencies, observations, supporting objective evidence, and any follow-up details. So audit reporting also includes description of audit aim, purpose, scope, the number of non-compliances, summary of audit findings, description of good points, any areas of concerns, description of identified opportunities for improvement, recommendations made because of the audit findings. So these are all part of audit reporting. Next. Then audit follow-up is done, verify that the actions are implemented, ensuring short and long-term effectiveness of those actions taken, recording follow-up details and objective evidence reviewed, and sign-off forms. So this concludes the auditing process. So now registration process details will be explained by Praveen.
Thank you, sir. So now here onwards, I will be taking forward this PPT slides further. And firstly, I would like to thank Atul Suri sir for providing us this Sunday a complete full day training program to understand the requirement of ISO 27701 2019 standard and its requirement. And again, from bottom of my heart, I would like to thank Atul Suri sir again for giving his valuable time, sharing his expertise, his knowledge, and enlightening us with the knowledge of standard. So thank you, Atul Suri sir. So now I am taking these PPT slides forwards, and post these slides, we will be having a question answer session to resolve your queries and questions. So so this is the registration process, basically explaining or showing up the auditing registration complete core process. So firstly, initially there is the application process. In the application process, basically critical information is shared by the client with the certification body. The critical information like number of employees of the company, sites of the company, and scope for which for the certification which applying. So all these kinds of critical information is mentioned in the application form, and post that client sign up is done. And during the client sign up, technical code is allotment, and commercials are finalized for the certifications. And after that, the stage one audit is conducted. During the stage one audit, documentation review documentation is reviewed and checked that how the documentation is meeting the requirement of standard as per the standard or not, meeting the requirement or not. Then followed by the stage two audit. During the stage two audit, implementation of the management system relevant, basically for which for which certification is applied. For that standard, basically the implementation is to be checked and verified during the stage 2 audit. And post that, if the observations or NCs or any area of improvements are provided or given by the auditor during the stage 2 audit, the client or the organization has to submit the NC closure with the proper evidences. And after the evidences and NC closures are verified by the auditor, then a review is packaged and certificate ISO certificate is issued from the certification body side to the organization or to the client. And post that, basically ISO is a 3-year cycle. So after every 1 year, the organization has to go under the surveillance audits. It could be annually or it could be semi-annually, or for this after 6 months. So it depends upon the organization only. And during the surveillance, basically the site addition can be done. If any scope, if scope is changes or edited in the current scope, that can be done. Basically, any changes in the organization that can be included during the surveillance audits. And after surveillance 1 and surveillance 2 audit, once the 3-year cycle is completed, every 3-year cycle, the organization has to go for the decertification process. Right. So basically, this is the complete core auditing process cycle for ISO certification. Sagar, can we move on to next slide, please? Thank you. So basically, about the Quality Asia, we are providing certifications and internal auditor training programs for below standards. Firstly, we have conducted trainings for ISO 9001, that is Quality Management System, ISO 14001, Environment Management System, ISO 45001, Occupational Health and Safety Management System, ISO 50001, that is Energy Management System, ISO 27001, that is Information Security Management System, ISO 22000, Food Safety Management System, ISO 13485, Medical Device Quality Management System, ISO 26000, Social Accountability Management System, ISO 42001, Artificial Intelligence Management System. And today we have conducted the training for ISO 27701, that is Privacy Information Management System. Next slide, please. Yeah, so about the Quality Asia and about its accreditations. At Quality Asia certification, our commitment to excellence is validated through our prestige accreditations. And at Quality Asia, we are proud to be recognized by the leading national and international accreditations body, including NABCB, that is National Accreditation Board of Certification Body, and IEF accredited, ensuring the highest standards of quality and compliance. Our accreditation reflects our rigorous adherence to industry standards and our dedication to providing reliable and trustworthy certification services. These credentials are a testament to our expertise and our unwavering commitment to delivering the value to our clients. And basically, our top management is the proud BNI member as well, that is Business Networking International member. Next, please. So I am delighted to introduce our leadership team. Firstly, Mr. Atul Suri sir, he is a lead auditor and reviewer. He is responsible for leading the team of auditors and establishing excellence in auditing operations. Mrs. Sima Suri ma'am, Director Accreditations. She is responsible for maintaining accreditation status and heading audit review and certification decision process. Mr. Samar Suri, he is Managing Director of the company, responsible for marketing and promotions and ensuring right visibility of the certification body. Ms. Palaka Ahuja, General Manager Certifications, responsible for heading and managing certifications and operations and ensuring client success through certifications. Next, please. Mr. Praveen Singh Negi, that is myself, Business Development Head, responsible for heading sales team and ensuring customer acquisition in a most ethical, right manner. Mr. Sagar Mohar, Quality Assurance Officer, responsible for compliance with accreditation standards, manages documentation, audits, and assists in training programs and supports marketing and operational excellence initiatives. And also we have a team of panel auditor in Pan India who is responsible for conducting ethical and quality-rich audits, enabling organization to understood and upgrade their systems and processes. And also we have a team of executive who is responsible for managing the show behind the scene. Next, please. Yeah. So training information evaluation, once this training session gets completed, you will be receiving a mail from the Quality Asia certification side, and in that mail you will be getting attached a training material, that is the training PPT, which we presented you during this training session. Then you will be receiving a training evaluation Google form link. And in that Google form link, you have to submit your examination for today's training. And the deadline for that submission of that examination is tonight, 11:59 p.m. So be kindly ensure that you have submitted your examination by today only. And also you will be receiving a training feedback link that is a part of today's evaluation form. So I request kindly all participants to provide the feedback for today's training so that we can improve our training programs in near future. Next, please. So about the Quality Asia School, we are providing, as you know, that we are providing free internal training programs. So you can just go to our website and access their Quality Asia School. We have a LMS learning portal. So you can just access the training recorded training video over there and get yourself certified over there after watching the video. Submit your examination, and also you can join us the Quality Asia School for the live training sessions on the WhatsApp channel. I will just show you the glance of all these things once the PPT completed. Next, please. Sagar, the PPT is hanged up. Can you move the PPT slide to next, please?
Yes.
Yeah,
Wait a
all
minute.
right. Yeah, thank you, Sagar. So there are two more trainings, upcoming training schedule for the next coming months or this month only. So the first training which will be having ISO 22301 internal auditor training program. The training name is that, and the standard for which we are providing training, it is Business Continuity Management System, BCMS, and the date is 29th June 2025, and the registration link is provided over there. So we will be sharing this PPT with you as well. So you can get this link access out to this link from the training PPT as well. And post that we will be having another training session for ISO 20000-1 internal audit training program. The standard is IT Service Management System, that is ITSMS. And the date will be 27 July 2025. And also the same link, also the link for this registration will be provided in the PPT only. So we are having two more trainings in the upcoming months. Sagar, next, please. Yeah. So you can join Quality Asia Certification Private Limited by the social media, that is Instagram, LinkedIn, and YouTube. So these are the links provided. Also, I want to update that the mail you will be receiving. So all these links will be provided on that mail only. Instagram, LinkedIn, WhatsApp channel, and Quality Asia YouTube channel. So you will be getting all these links and can get access to these things from your mail, which you will be receiving after the training session completed. Next, please. So thank you. So now I am presenting a few glances of our website and other things. Sagar, can you stop the sharing? I just want to show you our website. Basically, this is our website front page, home page. So this is the Quality Asia School. So you just click on that Quality Asia School, and here is you can access the free LMS learning portal. So here you can just get access all the training videos. Like I just want to open just one that is ISO 26000. Just you can just click on that arrow, and you will get access to the training video, that is recorded video. And like this, you can just watch this training video, complete the training watching video, and from here this is the training material link. So from here you can just download the PPT, and you can download it for your future reference. That is the training PPT. And for below the training PPT, quick link, there is a certification exam link. So you can just watch the video, enhance your knowledge, and submit the examination for the relevant ISO standard. And after the successful submission, and if you qualified for the examination, I mean if you will be getting the 50% marks in the relevant examination, you will be awarded with the certification for that particular standard. So that is anyhow, any chance if you missed any of the trainings earlier in the past, or if you miss today's training as well, it will also be get uploaded within 7 to 15 days. Coming 7 to 15 days. So you can just if you have missed any of the, you can say, training clauses during the training due to some emergency or due to some occupiedness, so you can just watch this video again and get enhance your knowledge again. Also, I just want to show to you that how you can check your you will be after completing the training and submitting successfully the training, you will be this type of certificate you will be receiving. Qualified candidate will be receiving this kind of certification. Quality Asia logo will be there, training certificate, your name will be provided over there. Then followed by the ISO standard, relevant standard, internal audit, and the date. Now you can see that we have mentioned the 2 days date. Basically, internal auditor training program is for 2 days. So we have conducted in a single day. Basically, we have covered all the requirement for the internal auditor training in a single day. So we have covered all the training and we will be showing the 2 dates so that it can be validated, so that it can be eligible. And here you will be getting the certificate number over there, then date of issue and the authorized signatory. And now you can just validate these your certificates on our website also. I can just show it up to you. Show it to you just a second. Like you can just go to the search, click on the training certificates. So here there are two sub options: internal auditor training and lead auditor training. So as of now, we are not providing lead auditor training. So you need not to go to lead auditor training. Just click on the internal auditor training. And like this is a unique certificate number. So I just click on that and I searched. So it will show up like this: the candidate name, Praveen Singh Negi, training program, ISO 50001 2018, training date 24th and 25th November 2024, and date of issue when that certificate was issued. So by this, you can just validate your certificate and there is no expiry of this certificate. It is valid until your as you can use it. Correct. And now I just want to show up to you like our social media. So basically you can just connect with the Quality Asia by going to the qualityasia.com Instagram and just follow up on this, and just you will connect it with the Quality Asia Certification Private Limited on the Instagram. Also, you can just go to the LinkedIn page of the Quality Asia. So linkedin.com. So and over there you can just follow the Quality Asia certification. And over there, you can just follow the Quality Asia certification link and you can just connect it with the Quality Asia certification on the LinkedIn page. And regarding youtube.com YouTube channel. So basically, we have a YouTube YouTube page of YouTube. We have presence on the YouTube as well. And also we have uploaded all the training videos on the YouTube. So you can just watch that. Here all the training videos are uploaded, like ISO 42000, 26000, 13485, 27, 22, right? And other training as well. 45, 50, 14, 9. All training videos are uploaded. You can watch the videos and enhance your knowledge. And also you can just share these links and relevant information with your you can say colleagues, your friends, whosoever are requiring this training, and they can just attend these videos and upgrade their skills and enhance their knowledge and become the industrial professionals. Okay, and I just want to show up to you WhatsApp channel. Basically, this is our WhatsApp channel, free ISO internal auditor training Quality Asia certification. So we are just updating all the information related to trainings, like registration link. Like today also we have shared the information today morning only. The Google meeting, sorry, it's the team meet link over there for trainees who are not able to receive any mail or message like that. So you can just associate with us. You can just get you updated through this WhatsApp channel as well. And also you will be receiving this WhatsApp channel on the mail as well. So that's all from my side regarding the Quality Asia website details and social media and all the things. And lastly, I would like to thank all the dear participants who are very much actively participated, having the patient complete for the whole day from morning until evening. And I am very thankful to all the participants for so much cooperative and understanding. So thank you. And now I want to start the question answer session. In the meanwhile, Sagar, you can just prepare the link. Prepare the mail, and you can just shoot up with the participants in the meanwhile.
Yes,
Okay.
yes,
All right,
yes,
Sagar.
it is.
All right. So I request participants, you can just raise up your hands one by one and speak up with your queries so that we can resolve your queries to the best. Yes, Mr. Devdeep Ghosh, please unmute yourself and speak up. Mr. Devdeep Ghosh, kindly unmute yourself.
Praveen ji, am I audible to you?
Yes, yes, you are very much clearly audible.
प्रवीण जी, एक्चुअली माय क्वेरी इज, मेरा क्वेरी था कि मैंने ना ये जो ISO ये जो BCMS और SMS का कोर्स था, तो मैंने ना बहुत पहले मैंने आपका वेबसाइट में देखा था, तो मैंने रजिस्ट्रेशन किया भी था, बट ये हुआ कि ना कुछ भी कॉन्फर्मेशन नहीं आया था। फिर मैंने मल्टीपल टाइम किया, तो मल्टीपल टाइम वो फॉर्म एक्सेप्ट भी हो गया था, पर कोई कॉन्फर्मेशन भी नहीं आया था उस रजिस्ट्रेशन का। और अभी मैं देख रहा हूँ आपकी वेबसाइट में ना वो लिंक जो लाइव ट्रेनिंग वो भी अवेलेबल नहीं है, तो वो क्या आपको मेल में अभी जो मेल आप भेज रहे हैं उसमें वो लिंक मिलेगा फिर से रजिस्ट्रेशन करने के लिए?
यस यस सर, सर आपके साथ जो पीपीटी हम शेयर करेंगे, विद इन दैट पीपीटी आपको वहां पे लिंक मिल जाएगा, और मैं सागर से रिक्वेस्ट करता हूं कि वो मेल कंटेंट में ही जो अपकमिंग ट्रेनिंग्स है उनके लिंक भी अटैच कर देगा, so that you can register yourself for the further trainings.
Okay, thank you Praveen ji.
Thank you, sir. Thank you, Devdev ji. Next, Mr. Dr. Santosh Rane ji. I request Rane ji to unmute yourself and please speak up with your query. Santosh ji, am I audible?
Am I audible to you?
Yes, sir. You are clearly audible. Please, sir.
Fine. So first of all, I'm sincerely thankful to you for organizing this particular kind of a training. It was a highly informative training program. And thanks for the orientation regarding the quality Asia. So my first question regarding the examination, particularly the kind of the questions what we have faced in today's 6 quizzes, whether our examination will be like that only, or some different level of questions will be asked, because we need to prepare for that.
Right, sir. Firstly, sir, thank you for the appreciation, and thank you for recognizing our efforts. And regarding the examinations, yes, sir, you will be having the examination like this only, but a little bit, but not like simple as that during the workshops. It will be a little bit technical and knowledgeable. So, but the questions will be objective only, objective.
Okay, because we need the reference material as you have already advised. So some time for reading that reference material so that we can appear the examination. That is the only concern about it.
Yes, sir. After this call, within 5 or 10 minutes, you will be receiving the mail, and in that mail, you will be receiving the training PPT, feedback link, and training evaluation link, and all the links regarding the social medias like Insta, YouTube, and WhatsApp.
Okay, sir. And shall I get any phone call from Quality Asia, because I want to talk at length regarding some training activities. So I have shared my number with you. So
yes, sir. What I'll do, I'll just once it is completed, I will share my link in the chat box. Sagar, can you just share my any of the number in the chat box so that Dr. Santosh Rane ji can get connected with me?
Okay. Yes.
Thank you, Sagar. Sir, we are just sharing my contact with you, and definitely we will connect with you shortly.
Thank you, sir.
Thank you, sir. Swati Kulkarni ji.
Yes,
please.
sir. Yeah.
Yes, Swati.
Thank you for this training session, sir. Actually, my query is that how do you handle the changes to the PIMS and PI processing activities? Like, what's the process for updating our PIMS documentation, and the procedure when we introduce a new PI processing activity?
All right, Swati ji. I'll just check with Atul Suri sir. Atul Suri sir.
Can you repeat the question once again?
Yeah, how do we handle the changes to the PI processing activities or PIMS activities? Is
See,
if there is any change?
first
Yeah.
thing is you need to refer to basically two things are there. One is your contractual requirement, and the second thing is the regulatory requirements. So if there
Okay.
is any change in contractual requirement or regulatory requirements, or if you feel like that, of course, because documentation, you're implementing various management system standards, so there is always an opportunity for improvement. There is always a scope for improvement. You can
Okay.
simplify your processes, you can detail your processes, you can based on the inputs from various stakeholders, you can modify your processes. So basically need has to be
Defined.
need has to come from either your own processes, either through your internal auditing, or more importantly any changes to the regulatory requirements or the contractual requirements.
Okay. Okay. Yeah. Yeah.
But
Thank you.
then you need to follow your procedure for management of changes,
Okay. Okay.
change
Yeah.
management procedure.
Okay. Okay. Thank you. Thank you.
Thank you, Swati ji. Is
Yeah.
there any more query?
Yeah. I have one question that I attended the lead implementer training, JMC in March. Despite passing the exam and receiving confirmation that my certificate will be issued within the 7 to 15 days, I still haven't received it. So I just want to check the condition of my certificate.
Yes, Swati ji. Actually, the notification or mail has been shared with the participants that there is no certificate is going to be issued for that. You are just appreciation mail has been shared with you.
Okay. Okay. Yeah. Thank you.
All right, Swati.
Okay. Fine. Yeah.
Thank you. Thank you, Swati ji. So, is there any more query from participants? Can raise up your hands and unmute yourself one by one. And we are here to resolve your queries and questions. Yes, participants, any more queries related to standard, related to today's training? All right. Sneha Kavatkar ji, please unmute yourself and speak up your query.
Yeah, good evening, everyone. Thank you for this
Good evening.
wonderful training. I just wanted to understand this DPDP Act, which is still pending for enforcement, right? So how do we basically use this for implementation purpose? Just wanted to get an idea about that.
See,
Yeah.
what you need. Yeah, I will explain.
Yes.
See,
Yeah.
if you refer to the DPDP Act, that is the draft rules. So normally, see, Act was made in the year 2023, but
Correct.
unless the rules are implemented, it is not mandatory. Fine. So
Correct.
Act is more like because based on the Act only the rules are made. So what you can do is normally what happens is because see these kind of in India we have a provision that for various rules there is always a stakeholders involved. So stakeholders always give some suggestions because industry is a very big stakeholder. So ultimately industry has to implement that. So normally industry representatives and like FICCI, SOCAM, different trade organizations, they also give their suggestions related to what can be implemented or what cannot be implemented. But most of the time it happens when the final version comes, because draft rules are already in public domain and you can just put it up in the net, these DPDP draft rules, so you can
Rules.
get a
Yeah.
copy of that. So you
Yeah.
can get a copy of that. So at least you can start doing, let us say for example, because ultimately it has to be implemented by all organized, especially the IT companies. So what you need to do is you can make some checklists or some checkpoints from that rules, because 90% or 95% it could be the same context, and 4-5% or maximum 10% there could be some changes. So at least you can do a gap analysis what all your organization is doing, or what are the challenges, or what further needs to be done. So I would recommend you make a gap assessment report based on the existing provisions, that is existing draft rules, and once the final version comes, then you can basically refer what changes have happened with respect to the draft rules. But at least you can start preparing based on the existing draft rules for your organization.
Yes. Thank you, sir. Thank you.
Thank you.
Thank you, ma'am. So any more queries, can raise your hand and unmute yourself, speak up, so that way we can resolve your queries. All right then. No more queries. So Sagar, have we shooted the mail?
Yes, yes, yes.
All right. So I request all participants kindly check your inboxes or mailboxes, because the mail has been shared with you all on your registered mail IDs. You can just check that have you received the mail or not. And those participants who have received, they can just submit your examinations and feedback over there. So all participants, the training has been officially ended here. I request all participants who have received the mail, training evaluation mail, they can just submit your examinations and they can leave this link, or you can just submit by staying here only. It is your wish or your call, because the training has been officially ended here. And those who haven't received, I request them to kindly share your mail IDs in the chat box, so that we can just share the mails with those who haven't received as of now.
So Praveen, there is a question raised by Swati, and she has asked, how do we balance security and privacy requirements? So I just want to answer this question. See, as far as privacy requirements are there, these requirements are covered by the law, like DPDP Act or GDPR, depending upon what all is applicable for your organization. So you cannot have any compromise on legal requirements, because any violation will cost a huge amount of money for the organization, and as you must have read in the draft rules also, the penalty is in
Right.
hundreds of crores of rupees.
Yeah.
So on that part, you cannot compromise. Whatever is required by the statute or the law, you have to implement. But balancing with the security requirements, then because security requirements, there is a cost of implementation. So that you can always balance off with respect to the resources and with respect to the client requirements and your own, what I call is your effectiveness of your own control measures, as well as the competence of your team. Because security part you can balance, but privacy requirements you cannot neglect or overlook anything, because any negligence or any violation on part of organization will cost a huge penalty for the organization. So
Okay.
my suggestion is privacy requirements, whatever is statute, whatever is the legal requirement, whenever it becomes applicable, there is
Okay.
no escape route for that. You have to implement whatever resources are required. The organization has to provide those resources. It is like
Okay.
if you have to pay income tax, that is our liability, we have to pay,
Yes.
whether we like
Yeah.
it or not. But
Right.
in case of security, there is a flexibility depending upon your client requirements, depending upon the processes, you can balance that off.
Okay. Okay. Yeah. Okay.
Yes,
Thank you. Thank you.
thank you.
Thank you, Sneha ji. Oh, sorry, Swati ji. Thank you, Swati ji. I hope your query has been resolved
Yes.
to the best.
Yes. Sir. Yes. Thank you. Thank you so much.
Thank you, Swati. So I request again to participants to kindly check your mail inboxes. We have shared the training evaluation link with you on your mail IDs. Those who have received, they can submit their examinations. The training is officially ended here. We are here just to provide you the mails who haven't received. And those who haven't received, kindly share your mail ID in the chat box, so that we can share the mail with you again. Sneha ji received. Thank you, Sneha ji. Thank you for such a wonderful audience today. Sagar, I request kindly check. There are so many mail IDs has been shared in the chat box.
Yes, I have checked them and shooted again. So they will
Okay.
get in 2 to 5 minutes.
Okay. All right, Sagar. Thank you. So I request participants who have shared their mail IDs in the chat box. The mail is again shared from our side. I request kindly wait for 2-3 minutes and recheck again your mailboxes. Yeah, Mr. Babin received. Thank you, Mr. Babinji. Such a wonderful audience and attending today's training session. I hope definitely we will be providing these kind of trainings in upcoming months. Thank you, Lakshmiji. Thank you for attending today's training session. Hope definitely we will meet soon. Thank you, Alvinji. Thank you for attending the today's training session. Thank you, Bara Neerajji. Thank you. Thank you for your appreciation. Yeah, Mr. Alvin. Yeah, thank you, Mr. Alvin, for your appreciation. Regarding your query, that you are saying that any course related to ISO 17025. So as of now, we haven't scheduled any of the training for ISO 17025. And for ISO 13485, we have already conducted the training session for this standard, and it is already uploaded or on the YouTube as well, and also on our website, Quality Asia LMS School. So you can just go to the website, go to the Quality Asia School, and get the access to the training video, recorded training video for the ISO 13485, and watch the video, submit your examination, and get certified. Yeah, sure. In future, we are not having any schedule of ISO 13485 as well, because we have already conducted the training for this in the past. Thank you, Arvindji. Thank you for your kind words. So, dear participants, we are here just to provide you the training evaluation mail. So I just want those who haven't received, kindly let us know so that we can assist you with providing the mail or training evaluation link so that you can submit your examination for today's training. And those who have received the mail, you can just submit your examination for today's training. The training has been officially ended and completed. You can just left the link